Your Lordship says the same issue has already been decided. Item 13.
That the post the learned counsel appearing on behalf of the submits that it instructs accordingly the stands closed on withdrawal.
Not
You are there?
No, Lordship. I have to mention item number 6, Lordship. Can it be on Friday?
Team number?
6.
No.
Lordship, I do not have the brief. Brief is with Mr. S. Chaudhary. He is out of session.
Who?
S. Chaudhary, second person.
But this is a 2017
Yes,
matter.
Lordship.
Doesn't it?
Friday, Lordship. For disposal Friday.
We'll see when the matter is.
My lord, I beg to mention this to read petition for listing as admission matter, my lord.
For?
Admission matter, my lord.
Understood. What is the matter about?
Matter about contractual bill amount, my lord.
Huh?
Contractual bill.
Not for
Non-payment of contractual bill, my lord.
We'll have it in the month of 10th of November.
Thanks, my lord. Publish, my lord.
My lord, I beg to mention item 44 and 45. There's a similar matter, my lord. IA 228 of 2025. I pray that these two matters
Huh?
may also be listed. There's a similar matter, my lord.
Hmm.
So I pray that these two matters may be listed together with that order.
Which?
Item. My lord, item 44 and 45. There's another similar matter, my lord. IA 228 of 2025. So I pray that these two matters may be listed together, my lord, with that.
With whom?
With IA 228 of 2025.
We'll see why the matter has come up for orders.
All right.
We have filed an
May it please your lordship. Lordship, I pray for listing a new matter, lordship. Matter related to settlement of fishery, lordship.
When? Motion?
Tomorrow? Yes, lordship.
Hey, it's 21.
May I please your lordship? The lordship, with respect to item number 57, your lordship, others matter, your lordship. The lordship may recall the very last order. Here, your lordship, the challenge is with regards to your lordship, the cancellation of letter of acceptance if any other similarly situated SUI bidders, your lordship. Your lordship, we have secured our credit guarantee scheme, your lordship, under SUIS, your lordship, but we have not availed that particular credit guarantee, your lordship.
You are for the?
Your lordship, I'm seeking for an implement in this writ petition, your lordship. The matter has been fixed, your lordship. So, your lordship, I pray for this to interlocute the application for listing as an unlisted and be tagged with item number 57, your lordship. Much obliged, sir.
We have also filed the affidavit of service to them. That will be called.
Much obliged, your lordship.
May I please your lordship? Lordship, I beg to mention item number 26. Matter is become infractuous, my lord.
26.
Item number 26.
Your name?
H.J. Tamul.
Huh? H.J. Tamuli.
Lordship.
H.J. Tamuli, the learned counsel submits that the petition has become infractuous and therefore submits that the petitioner would not like to further proceed with the instant proceedings. Taking into account above, the petition stands closed as infractuous. Interim orders, if any, stand vacant.
Obliged, my lord.
May I please, your lordship? Lordship, I beg to mention item number 18, lordship. May be adjourned with another day, lordship.
What is this matter about?
Cancellation of tender, lordship.
You are for?
Mr. A. Ahmed, petitioner, lordship.
There's a stay.
No. Lordship, actually, my senior today could not attend the court, lordship, due to health issues, lordship. Kindly adjourn the matter, lordship, after 3 weeks.
Whether there is a stay or not.
No, lordship.
At the request of the learned counsel appearing on behalf of the petitioner, matter stands adjourned to be listed after 4 weeks. It has been submitted that there is no interim order passed in the instant proceedings.
Obliged.
May it please your lordship, I beg to mention for listing admission column, your lordship.
For
The matter pertains to the non-delivery of possession of land, your lordship.
non-delivery of possession,
Oh, yes, yes, your lordship.
we have it on 3rd of November.
Lordship.
For motion item 1.
May I please your lordship?
Yes.
So
What is this?
petitioners are the fair price of license holder, lordship.
Their licenses have been cancelled on the allegation that misappropriation of rice for the month of July and August 2022.
Your PDS license has been cancelled
Yes, Lordship.
without notice.
Show cause notice, Lordship, is given, Lordship.
Then
Lordship,
appellate authority also has cancelled it.
cancel it, Lordship.
Now,
Now, Lordship, my case is that, Lordship, I have filed RTI application. In the RTI reply, Lordship, stated that we have, Lordship, for a moment, kindly see the RTI reply. That Lordship will find at page number 85. By this letter, they have given the RTI information report. We are seeking report regarding the distribution of PMGK rice. If your Lordship, for a moment, kindly see the page number 86 for the month of June 2022. Lordship, from bottom, Muhammad Samiruddin is the petition number 1. Lordship, kindly see the total cards 316, avail cards 290, percentage of 91.77. So almost, Lordship, they have lifted rice or distributed rice. But allegation is that on a complaint filed by some of the consumers, but allegation is specifically for this Samabhai society. We have lifted rice from that particular Samabhai society. Where as in Lordship.
let's see the impugn order.
Yes, if you Lordship order, Lordship will find it. The cancellation order. Annexer H series, page 57. May I read, Lord?
We are concerned with Nazir Hussain.
Nazir, there are 4 number of petitioners.
Why?
The same Lordship. Their cause of action is same Lordship.
How can they have a cause of action same?
Lordship,
Everybody has a different license.
license is different, but the order is Lordship on the pass on the same
What?
one.
It cannot be all together. You cannot file one petition for everybody. Everybody has a different license. Everybody may have been given a different scope of appeal. Everybody may have a different
No,
reason.
allegation is same for the month of June and July.
So what? Everybody has a different cause of action, Mr. Counsel. You cannot have a single cause of action for everybody. You have to file 4 different petitions if you are to challenge it. You cannot challenge in this regard. Everybody has a different thing. Here it is a case of Nazir Ahmed.
Yes,
This is the
Nazir Hussain Lordship.
Then what about the others?
Their Lordship, next page Lordship.
So these are all separate orders.
On 20.
Habibur Rahman, these are all separate orders. How can you challenge by one writ petition, Mr. Counsel? No.
Then I will take in for the petition number 1. I will file separate petition for the other petitioner, but Lordship may accept this for the petition number 1.
Okay,
Nazir.
who is he?
Nazir Hussain,
Nazir Hussain.
Lordship.
Then
Lordship, the paragraph number inquiry report is fine. And we have Lordship distributed Lordship rice by maintaining the EPOS machine. They're saying that Lordship did not maintain register for this 2 months, July and August. But we distributed rice through the EPOS machine, electronic by Lordship. It's known as electronic point of sale, Lordship.
let me issue notice. Only one notice. In respect to petitioner number 1. Heard Mr. A. Decker, the learned counsel appearing on behalf of the petitioner. Mr. M. Teti appears on behalf of the respondent number. All the respondents. Extra copies of the writ petition be served upon him during the course of the day, within 2 days. By Friday. Issue notice. Issue notice. Heard Mr. Nayanalak. Issue notice returnable on 1st of December 2025. Mr. MCT appears on behalf of the respondent, all the respondents, and extra copies of the petition be served upon him by Friday. At the outset, Mr. Adaka, the learned counsel appearing on behalf of the petitioner, submits that taking into account that all the petitioners have separate causes of action, the instant writ petition be confined only to the grievance of the petitioner number 1. And as regards the other petitioners, the petitioner may be granted the liberty to withdraw themselves. Other petitioners, that is petition number 2, 3, and 4, liberty may be granted to the said petitioners to separately file writ petition, if so advised. Taking into account the above, the names of the response petitioner number 2, 3, and 4 are struck off. Liberty given to the petitioner number 2, 3, and 4 to file separate writ petition, if so advised. The counsel for the petitioner is directed to file a fresh memo of parties before the registry of this court by Friday. In consonance with the order so passed herein. And the registry shall, on the basis of the fresh memo of parties as well as the order passed herein, make necessary correction in the cause title as well as update the same in the CIS. The petitioner herein is aggrieved by the cancellation of its license pertaining to the license of Fair Price Shop, as well as the appellate order dated
1/7.
1/7/2025, whereby the cancellation of the license have been upheld. The learned counsel appearing on behalf of the petitioner submits that the cancellation of the license as well as the upholding the order of cancellation of license are based upon grounds which are not in existence, and as such requires interference by this court under Article 2 to 6 of the Constitution. The respondents herein are directed to bring on record their stand by filing the affidavits on or before 24th of November 2025, and shall also ensure that on 1st of December 2025, the date so fixed, the records are made available just accordingly.
I do
বিপ্লব রায় লর্ডশিপ।
Yes, Mr. Ghosh. What type of matter is this?
My lord,
Something to do with Indian Oil?
my rejection of my lord,
Where is an Indian Oil counsel?
my lord,
You have served it, you have not served.
my lord, they have no standing counsel.
They have standing.
No, my lord, I am told that.
No, you
Only
have
the
to
notice
keep them.
goes, then they, my
But
lord.
what is this type of matter that you have enclosed? This see this petition. Yeah, dear. Good idea. What are these type of petitions? Tell me.
Oh, my, I'm sorry, Lord. I'm sorry, my lord. Sorry, Lord. I'm extremely sorry, Lord. I'm extremely sorry. You will.
Indian Oil has a council. Give it to them.
My lord, actually, other cases also, my lord, I offered, my lord. They said only after issue of the notice, they only engage the council, my lord. There are no panel standing council. That
Okay,
is
what are you challenging?
my lord, I am challenging a cancellation order, my lord. My rejection of my
Cancellation of
candidate.
what?
Rejection of my candidature, my lord.
Yes.
Yes, my lord, I have applied for the retail outlet. My lord, I belongs to SC category. And this site was exclusively reserved for the SC category.
Which is the retail outlet?
My lord, that my lord will find page 31, my lord.
Serial number?
Serial number, I am serial number
Within 5
70,
kilometers of Dorongi.
76, my lord. Within,
Durnoi.
yes.
This is a SC.
CC1, my lord, combined category that is belong for person, my lord, personnel from the defense and paramilitary forces. I am from the paramilitary force, my lord, retired person. From the
So it
paramilitary.
is for SC and CCI.
Yes, my lord.
Okay, then
So-
what happened?
Then, my lord, actually, I submitted all the documents, my lord. I executed lease deed with the, my lord, the lesser, my lord, and I submitted the documents.
Where is the lease deed?
My lord, that lease deed, lordship will find at page, my lord.
What is the last date for submission?
Last date, we have submitted, date was extended, my lord.
Okay, what was the last date for submission?
We submitted on 15/10/23.
What was the last date for submission?
Actually, my lord, it was, it was extended, my lord.
What is the last date? for
Yeah, I understood,
submission?
my lord, but that information I don't have, my lord.
Then, okay. And you submitted on
I have 15/10, my lord,
15/10.
23, lordship.
Then
My lord, then I was provisionally selected, my lord,
as
as my lord, group one. Group one.
Okay, where is your lease deed?
My lord, that my lord will find at, my lord, page, yes, my lord will find it page,
So you have taken it on lease from
Ananda Rabha, my lord. Ananda Rabha, that my lord will also
for a
find
period of 21
for
years.
21 years, my lord.
And the lease shall be 1,500 per month.
Yes, yes.
And you have registered that
I
document.
registered the document
When
also.
did you register it? 28.
28, my lord.
Okay,
Then, my lord, I submit, then they rejected it, my lord. My rejected my candidature.
so the ownership of the land is of 2 persons.
Yes, yes, my lord, only on that ground, my lord.
And then it cannot be done in view of this particular clause.
But my lord, there is a provision also, my lord, that even after selection, they can grant immunity to the other person also, that they can obtain NOC from the other owners, my lord. If the land is owned by the more than one owners, they can obtain NOC by of an affidavit, my lord. As
What?
per note 3, my lord.
There is no NOC business out here. Kindly come to page 36.
Yes, my lord.
A.
Yes, my lord. I've seen,
The land should be available with the applicant
Yes,
as
yes,
on
my
the
lord.
date of the application and should have minimum 19 years from the date.
Yeah,
of
that is
selection,
there,
but
my
not
lord.
later than so and so. If the offered land is on long-term lease and there are multiple owners, then the lease deed should be executed by all owners. And offered land, in case lease deed is not executed by all owners, such lease deed shall be treated as invalid. So what is wrong?
My lord, may kindly see note 3, my lord.
Note
Clause 6,
in
my
case
lord.
after three, if it is observed
Yes,
that the
my-
offered land is co-owned by multiple persons.
Yes, my.
And the provisionally selected layer did not provide consent of all the year, the provisionally selected layer would be given 21 days to get the consent of year for the offered land. And failing with the candidature of the provisionally selected would be rejected. However, for location advertised at the SC, such candidature shall get an opportunity along with group 3 applicants, provided he was originally not in group 3 or has been removed from employment. So, no case. I've dismissed many cases on this point. Bad case. Luckily, you have not disturbed the, what do you call those persons?
My lord, this is a discrimination, my lord, on there.
No discrimination. First of all, you should have got the year from both. I've delivered a judgment that day also. Oh, okay. Bad case.
And otherwise, my lord, I have also The provision contain the provision of sublease also in the in favor of my lord IOCL also, my lord, because there is the corporate fund scheme under the my lord. It has to be developed by them, my lord, not by me. So I can execute a lease deed.
If it is a corporate fund scheme,
Yes.
if the land concerned belongs to two other person, the other person will very well come over and say that no, I have not
And he
granted
has
the
filed
lease.
an affidavit, my lord, declaring that I have
Affidavit
no
won't help
objection,
it. Affidavit won't help it.
my lord.
Affidavit won't help it.
He said that by way of one family settlement, it has been given to my the leaser, my lord.
As on that date,
Yes, my lord.
you did not have a lease deed. That is why I asked you, what is the last date for submission?
My lord, lordship kindly
You
see
knew
the.
about this clause very well.
Yes, my
Then
lord,
why did
kindly,
you get
on
only
the
1
date
week?
of application I have, before that, my lord.
Huh? No. On that very date, you should have executed a lease deed from both. Why didn't you get it? Ananda Rabha and the other is Ananda
Yes,
Rabha.
my lord,
When the cancellation?
Cancellation, my lord, will finally pay 87, my lord.
Page
87.
87.
Yes.
That is. It is to inform you during field verification, you have failed to produce the original land document for verification Iman plan. So these did executed by Ananda Rabha and Nipun Das on Iman as per submitted land area belongs to two owners as per clause 4 dealers is the offer that area is well in case of clear. So you now become in group 3.
Yes.
So group 3, you offer that land properly again.
It is, my lord, actually it is duty of the company, because the investment will make by the corporation, my lord. Because the land should be in the name of the, as per their scheme, my lord. It should be in the name of corporation.
Mr. Ghosh, the question is, I may issue a notice only, no stay.
No.
But should I? There are 2-3 judgments I have delivered. Okay. I'm only thinking of issuing notice for the benefit of the other side counsel.
Okay.
So that the IOCL councils get some
Money.
Otherwise, no. Not for the benefit of your client. That is only the reason why I'm thinking of a notice. Therefore, I think we dismiss it. Heard Mr. B.J. Ghosh, the learned counsel, appearing on behalf of the petition. The petitioner herein is aggrieved by the communication dated 17/7/2025, by which the candidature of the petitioner in the group 1 category have been rejected and further mentioning that the petitioner would be considered along with group 3 applicants as per the guidelines. The facts of the instant case, as it appear, is that by an advertisement dated 28/6/2023, the respondent number Respondent number 2 have issued a notice for appointment of regular/rural retail outlet (petrol pump dealership). The instant petition relates to the retail outlet at serial number 76 of the said advertisement. The said serial number, the contents of serial number 76 being relevant to reproduce from a perusal of the contents of serial number 76, it reveals that the location of the retail outlet is within 5 kilometers of Dorangiri Banana Market towards Dunoi on NH 37 old/NH 17 new. It is further seen that the said outlet was specifically reserved for the categories of SC and CCI. Full stop. The petitioner, on the basis of the said advertisement, entered into an registered deed of lease with Ananda Rabha for leasing out a plot of land at measuring 2 bighas for a period of 21 years. Full stop. On the basis of the said lease agreement, the petitioner submitted the application on 15/10/2023 and claiming himself as a Group 1 candidate. Full stop. Upon the draw of lots, the petitioner was provisionally selected. However, on field verification being carried out, it was found that the the land actually belonged to the said Ananda Rabha along with Anant Rabha. On the basis of on the ground that there were 2 owners in respect to the land, and the petitioner had only entered into a lease agreement with only 1 owner. By the impugned communication dated 17/7/2025, the petitioner's candidature was rejected as a Group 1 category, and the petitioner was relegated to be considered along with Group 3 applicants. It is under such circumstances the petitioner has approached this court by filing the present petition. This court duly have taken note of the materials on record and have heard Mr. B.J. Ghosh, the learned counsel, appearing on behalf of the petitioner. A perusal of the brochure pertaining to selection of dealers for regular and rural retail outlet stipulates the manner in which the application is to be filed.
Yes, provision page 37.
It is further seen that in terms with clause 4, Roman 6 of the brochure, hereinafter for short the brochure, there are 3 types of, the applicants are categorized into 3 groups. That is Group 1, Group 2, and Group 3. Group 1 are those applicants who have suitable piece of land in the advertised location, area, either by way of ownership, long-term lease for a period of minimum 19 years, 11 months, or as advertised by the OMC. Group 2 are those applicants who have a firm offer for a suitable piece of land for purchase or long-term lease for a period of minimum 19 years, 11 months, or as advertised by the OMC. And Group 3 are those applicants who have not offered land in the application, only applicable for locations advertised under SC/ST category. The court further finds it pertinent to take note of clause 4, Roman 6A, which stipulates conditions as to what steps are to be taken when the offered land is on a long-term lease and there are multiple owners. Clause 4, Roman 6A being relevant is reproduced here in under. Page 36. A perusal of the above clause would therefore show that if the offered land is on a long-term lease and there are multiple owners, then the lease deed should be executed by all co-owners of the offered land. In case lease deed is not executed by all co-owners, such lease deed shall be treated as invalid. In the backdrop of the above, if this court duly takes note of Annexion 9, it would be seen that the plot of land which was leased out to the petitioner was a plot of land jointly owned by one Anand Rava along with one Anand Prabha. Full-stop. It is further seen from a perusal of the lease agreement, lease deed, registered lease deed, which is enclosed as Annex 7 to the petition, that the lease deed was only entered into by one co-owner and not by the other. Full-stop. Consequently, in the opinion of this court, that the respondents were therefore justified in terms with clause 4, Roman 6A, to hold that the lease deed the lease deed on the basis of which the petitioners applied as a group 1 category cannot be taken. Cannot be. Is an invalid document insofar as consideration as a group 1 candidate. Considering the above, this court does not find any ground for interference with the communication, the impugned communication dated 17/7/2025, for which
Clause
the
D, they may be considered. Clause D, my lord.
not clause, for which the writ petition stands dismissed. And I've given 6, 7, 3, 4 judgments on these.
Item 3.
May I please?
Yes, Mr. D. Sharma, what is this?
The petitioner's family has been possessing a plot of land since 1980, Lordship.
What?
And in this said plot of land, Lordship, though there is a.
Issued by APDCL.
Yes, your Lordship.
What have they done?
Lordship.
What have they done? APDCL.
PDCL, Lordship, actually, they cannot issue any notice because once the land has been possessing by the petitioner, there is no dispute that that land is under the possession. But they have threatening that they have not yet disconnected, Lordship.
Where is the notice?
Lordship, it's page number 32, Lordship.
Your name is?
Niranjan Sahu.
It is to bring to another new electrical capital was provided. So they have not disconnected till now.
Not yet disconnected.
So how are you possessing the land?
Lordship, the land has been possessing by the petitioner's family since 1980. And prior to that, that land was possessing by the maternal grandfather of the petitioner, petitioner and Lordship, the petitioner's father. And accordingly, the land has been mutated in the name of, your Lordship will find at page number 14, Lordship. In the name of all the legal heirs, Lordship, Puspa Sahu, Pradip Sahu, Ajit Sahu. They are the Puspa Sahu is the elder sister of the petitioner's mother, and remaining two.
But your name is not there.
Not, Lordship, that was mutated without my knowledge. But land has been possessing still that, Lordship, that land is under my possession, Lordship. There is no dispute, Lordship.
Yeah?
Land has been possessing by me, Lordship, since 1980, and no, they have not claiming for any right over the land, Lordship.
So,
Possession. And Lordship, now only dispute,
then why did you get a connection with the power of attorney?
Lordship.
Why did you get a connection with the power of attorney?
Lordship, the disputes when arose between the family members, Lordship, at that time, Lordship, earlier it was not in the knowledge of the petitioner's family that that land has been mutated, leaving the petitioner's mother from the land record, Lordship. When it was came to the light, land, Lordship, on the husband of the respondent number 4 issued the power of attorney not to, Lordship, at that time not to disturb any
No.
They are
You got a connection on the basis of a power of attorney.
yes, sir.
Puspa Sahu.
Puspa Sahu.
Puspa Sahu now comes up before APDCL and says, look here, I have withdrawn this power of attorney. Now the question remains, if that power of attorney has been withdrawn, why you are not applying for a permission, application by yourself? Why are you before this court?
Lordship, I have
And
already,
if they don't grant the permission, the electricity connection, then come before this court. This is how you do it. What is this you have come before this?
Lordship, electricity connection has already been granted. Your Lordship will find.
Understood, but this has been done in the name of Puspa Sahu.
No, Lordship.
Yes,
This is in my name, Lordship. Your Lordship will find at page number 30.
but on the basis of a power of attorney.
Lordship, the land is mutated in the name of 3 persons. And one cannot.
Everything Mr. Sharma understood. But is it not the fact that you got a connection on the basis of a power of attorney of Puspa Sahu?
Lordship, only on the basis of the power of attorney issued by only one person, that is not enough to give Lordship electricity connection.
Not replying to them.
Lordship, we have replied, but they have
Where's
not.
your reply, sir?
Lordship, they have not reply. I have reply, Lordship. I have not
Huh?
enclosed here, Lordship. I may be allowed to
No.
bring it.
Dismiss with cost of 10,000 upon Mr. Counsel. Absolutely. Why you are making this incorrect statement before this call? You have replied. If you have replied, you would have obviously brought it on record.
Lordship,
Why haven't you replied to this notice?
Lordship,
should have
I
applied.
may be
You
allowed
should
to
have
take the
used-
instruction, Lordship.
Huh?
I may be allowed to take the instruction because,
No,
Lordship,
I'm dismissing it right now.
Lordship,
No.
Lordship,
If
the
you
only,
have a case, you have to be. You are not going to come before this court without your version known to the authorities.
only my humble submission
No.
before this honorable court is that
Nothing.
when the petitioner approached the APDCL, then he submitted an application. As per my knowledge, that
Why
application
should I
was not
listen to all
accepted.
these
Lordship.
things? Mr. Sharma, why should I listen to all these things when you have not made the APDCL know about these facts? Why haven't you made the APDCL know? You have been issued a notice and asking you to reply within 15 days. Why haven't you replied? And this notice was issued on 1/8/2025. We are nearing 1/11. Why haven't you replied? And just directly coming before this court?
Lordship, in this
We
regard,
dismiss with cost of 10,000 upon Mr. Sharma.
Lordship, I may
This is
be
not
allowed
the
to.
way. You
Lordship,
should have
only
advised your client properly. Ask them to go before that particular authority and file their reply. And then if they don't consider, don't give you electricity, then you come before this court. These are reasonable grounds. On the basis of that. What
Yes, regulation 4.2, my lord.
Lordship, on that,
Dismiss.
Lordship,
How much cost?
I may be allowed to withdraw, Lordship.
No, cost.
Because, Lordship,
No,
it was my, it was
I
my,
don't allow withdrawal.
Lordship,
It should be dismissed with cost upon you.
Lordship,
It cost upon you.
Lordship,
No. First of all, you should not have approached this. You should have first advised your client, give a reply. And
Lordship,
if they don't, give the reply and give them the basis of on the death of Dilip. Get a connection if you have any problem. And directly approaching this court.
Lordship, only my instruction is that, Lordship,
Where
when,
your instruction
when he
is
approached,
not
Lordship,
there.
when he approached the judicial authority, they neither try to meet him nor they considered
Mr.
his.
Counsel, you have been given time for 15 days to submit a reply. Where is that? Please be advised that you are granted 15 days from the date to comply with the requirement. If you fail to submit the necessary the electricity, we urge you to treat the matter with seriousness. Until now, you have the benefit of an electricity connection. They have not done anything. You should be happy. You should have kept quiet. Go there, file your representation, and submit that these are the facts. And then, if necessary, you get a connection. As per clause 4.2.
4.2 mile.
Or
ARC regulation mile. This three.
I may be allowed to. I will inspect my client because, Lordship, only
the
my,
cost of upon 10,000 upon Mr. Sharma.
this is the, Lordship,
Not
think
upon your client.
this is
I'm
my,
not imposing any cost upon the client. I'm imposing the
Lordship,
cost upon you.
only my instruction is that, Lordship, he
Your
was not.
Your
Yeah.
instruction cannot help you.
Only my, Lordship, earlier this matter was pursued by some other person, and thereafter he sent the records to me, and accordingly I have filed. But I asked him that, asked my client whether he has replied or whether he approached the authority. At the time, he only instructed me that he approached the authority. They assured that they will not disconnect. But
Very well.
but
If
they do not.
won't disconnect assured, then why you are filing the
But they,
petition?
Lordship, they do not try to accept any written application from them.
Are you making that statement? Where is the statement? In your affidavit?
That was my verb.
No,
That was,
Mr.
that was my
Counsel.
verbal instruction. Lordship.
Mr. Counsel, don't make these type of submissions unless it is backed by.
Yes.
We make it 10 to make it 20. 20,000 cost upon you.
Lordship, I may be allowed to withdraw.
With 20,000 cost
Lordship.
upon Mr. D.K. Sharma to be. Mr. D.K. D. Sharma, the learned Mr. D. Sharma, the learned counsel appearing on behalf of the petitioner, Mr. Bida appears on behalf of the FPPCL. The petitioner herein is aggrieved by the notice dated 1/8/2025 issued by the subdivisional engineer Moran Electrical Subdivision, whereby the petitioner has been asked to submit necessary documentation, thereby entitling the petitioner to the electricity connection. Full stop. This court specifically inquired with Mr. D. Sharma as to whether the petitioner have responded to the notice dated 1/8/2025. The learned counsel submitted that he has no instructions in that regard. It is the opinion of the court that if those necessary facts which the petitioner urges before this court are placed before the respondent authorities and respondent authority. No, it is the opinion of this court without placing the necessary facts before the respondent authorities, the petitioner cannot be allowed to file a writ petition before this court. This court further duly takes note of clause 4.2 of the
ARC regulation 2019. And
2000 ARC regulation
2017, my lord. Amended one is 2009. 2017.
2017.
17.
Which stipulates that taking into account the above, the learned counsel appearing on behalf of the petitioner submits that the petitioner would be well advised to approach the subdivisional engineer to approach the authority, respondent authority, by submitting an representation dated 1/8/2025. The learned counsel submits that if the petitioner is, however, aggrieved at a subsequent stage, he may be permitted to approach this court taking into account the above, this court is not inclined to entertain the instant writ petition. However, petitioner is granted the liberty to approach the respondent authorities by submitting a representation against the notice dated 1/8/2025. It is further observed that in the circumstance that the representation is duly submitted and the respondent authorities do not take care of do not consider the representation, it shall be open to the petitioner to approach the appropriate forum.
Item 4.
May I please?
Yes, Mr. Triple S Rahman.
My lord, this is my,
What is this?
my lord, non-payment of my lord amount of 12,84,909, my lord.
Year,
Year is my lord 2012, but my lord, I have filed my lord RTI, my lord, at page 31, my
yeah,
lord.
no, what? You are to get within 3 years.
My lord, that's right, but they
How
are not
will they
paying.
verify? No? Strongly object. Strongly object. We dismiss. Where is the judgment on Kumbhakarna? That day I got hold of one judge. Let me dismiss it on the ground of you being a Kumbhakarna. Where is the judgment?
My lord, actually, I filed an RTI, my lord.
Huh?
I filed an RTI.
No RTI business. On the basis you make an RTI after lapse of 10 years, how are they going to verify and find it out? No case. You better approach the civil court if on the basis of that. Heard Mr. Triple S Rahman, the learned counsel appearing on behalf of the petitioner, Mitch so appears on behalf of the Water Resource Department. The petition, Mr. Triple S Rahman, the learned counsel appearing on behalf of the petitioner submits that taking into account that the petitioner herein has approached this court seeking an writ in the nature of mandamus, thereby directing the respondent authorities to pay the amount of rupees 12,84,909 on the basis that the said amount is payable to the petitioner. It is duly taken note of that the amount on the basis of which the petitioner is claiming are amounts pertaining to the year 2012 and 13, and the respondent it has been submitted by the learned counsel appearing on behalf of the petitioner that taking into account that there are certain taking into account the respondent authorities in a recent communication dated 28/11/2024 have given a liability statement. The petitioner would be well advised to approach the competent civil court. So taking into account the above, the petitions that is closed on withdrawal. However, liberty is given to the petitioner to approach the competent civil court claiming the dues if so permissible under law. So the dismissal of the instant, the withdrawal of the instant writ petition, however, shall not prejudice the petitioner in any proceedings so initiate.
I'm right.
For admission, item 5.
Bokazan cement employees, none appeared. Oh, yes. None appears for the
Item 5.
petitioner on call. It is seen that the petitioner have not appeared before this court on various occasions. It appears, therefore, that the petitioner is not interested in the proceeding. Considering the above, the writ petition therefore stands dismissed on non-prosecution. Which one? When? It is again come, why?
Again, come for, I have a more copy of the mistake, for any restoration.
IA file করছেন?
I has not been.
Oh, no, no. IA আছে? Okay, IA আছে। Okay. এনেকে লেখো। None has appeared on behalf of the petitioner on call. It is seen that the instant writ petition was dismissed by an order dated 25/10/2024. Subsequently, disposed by an order dated 19/7/2025 restored the writ petition. Today, when the matter is being taken up, none has again appeared on behalf of the petitioner. Considering the above, it appears that the petitioner have been not diligent enough to pursue the present proceedings, for which the instant writ petition stands dismissed for non-prosecution.
Item 6.
MCT appears for the respondents. Yes, what is this?
I sought for adjournment.
Extraordinary learned counsel were granted 4 weeks' time to file affidavit in reply. Have you filed?
This case,
Your name appears in the cause list
yes,
glaringly.
yes,
at
Lordship.
the
Brief
top
is not with me, that's the
golden
problem.
letters.
Brief
And
is
then
not. with
also
me,
we don't find you. You say you don't know. Central Capital Investment Subsidy.
Subsidy loan.
Then
And less amount was granted, sanction released. And while calculating the
affidavit
expenditure,
filed on 29/3/2025. You have not filed your reply.
yes, so brief is not with me, that's why this is the problem. Lordship, this with S. Chaudhary, he's out of station. He has the instruction on. Otherwise, next day, Lordship, it will be disposed of. That's why it's got for some time in the morning.
It seems that the petitioner is not interested to pursue with the instant writ petition. It is seen that the petitioner does not have an inclination for an early disposal of the instant writ petition. Accordingly, list the matter in the for hearing in the usual course.
Seven.
Please, your lordship. On the last occasion, they were going to file a affidavit, your lordship.
Who?
BTC.
Lordship, we've just been recently agreed with appointed. Lordship, we need some time to file that.
Therefore, should we ask the registry out here that all BTC matters should be not listed any further? No, this can't happen. 1 week is okay. Last week, just before that, 1 week, we have excuse, but not now. If you don't have the brief, it's okay. We ask this person concerned to be appearing. There might be a change in there will be a change about the council. We are not bothered to that effect. You cannot delay this matter. If you have not filed a writ petition, we'll consider it that on the ground of doctrine of non-preverse. In the division bench, you can very well say that this court didn't listen very well. No problem with that. Now argue. We'll pass the judgment.
Short date.
No short date. We have cost of 10,000 rupees upon you. Otherwise, this is a payment, non-payment of dues. Non-payment. Who is appearing? You are appearing for the water resource. Does this scheme has anything to do with the central government? Understood. I'm only asking you. You are the counsel who is representing the respondent number 1 and 2. And if you are appearing for respondent number 1 and 2, respondent number 4 has filed an affidavit in opposition. What does he say? Affidavit has been filed. Then works mentioned in this paragraph were allotted to the petitioner by the then executive engineer. The works were executed under the jurisdiction under the Contractor WR division. The government of Assam created so and so. So the Tamilpur had fallen under the jurisdiction of executive engineer. So all related papers are so and so. Who has to file the affidavit?
My lord, Secretary BTC, my lord.
Why?
My lord, because this affidavit was filed by executive engineer, my lord, Upraja. So on the last occasion, my lord, this honorable court asked to file by the secretary.
Why is it necessary?
My lord, lordship, my lord, on the last.
No, this court never asked Ms. Barbara, who appears 2 weeks time, to file an appropriate affidavit in opposition to the secretary. Nobody asked. This will happen like this. 11/9/2024, I gave a last chance. 24. We are in 2025. This can't happen. Madam, only one thing. Does this have any issue with the central government? You just find out. We'll have it day after. Just find out that. If it is not anything, we pass the direction for payment within 6 months. After verification. Full stop. This court inquired with Ms. So-and-so, the learned counsel who appears on behalf of the respondent number. When a matter is being taken up, Mr. So-and-so appears on behalf of the BTC and pleads ignorance of the contents of the proceedings. On the other, this court and therefore inquired with Ms. So-and-so, who appears on behalf of the respondent numbers 1 and 2, as to whether the work in question had any relation with any central government scheme. The learned counsel submits that she would obtain instruction and place before this court on Friday. Accordingly, list the matter on 24/10/2025. Just check. Central government, is there anything to do? And BTC, you don't appear before me if you don't have anything out there. I don't want to see your face out here and say that the file has not been given to me. We are not concerned. It is your responsibility to get the file. And if not, if you are saying that the earlier council did not give the file, we may report this to council because you are interfering with the cause of justice. So next time, don't make any further submission. If you don't know, don't know. I can't help you with this.
Item 8.
Yes, what is this, Doctor Enterprise?
Yes, sir.
Oh, what is this?
This is the outstanding bill for which we have filed.
How much? 25 lakh?
Yes, but the so far they are happy with concern, they are only admitting 20 below 2050.
HPCL?
Yes, Lordship.
Why you are not paying?
The amount is disputed amount.
They are saying.
Bill amount is the disputed amount.
How much?
They are admitting. They
We are
are
admitting 47,415.
Huh?
And disputed amount is 24,75,000.
they are admitting on.
47 lakh? 47,000?
47,000,
You
yes.
said he is only entitled to 47,000 and remaining is disputed. Okay. Go before the civil court. I can't decide that aspect. No, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. So-and-so who appears on behalf of the HPC. The petitioner herein is aggrieved by the actions of the part of the respondent numbers 2, 3, and 4 in not making payment of an amount of rupees 25,22,448, which the petitioner submits that the petitioner is entitled to on the ground that the petitioner had performed, had made necessary, and carried out various works to the satisfaction of the respondent authorities. It is seen that pursuant to the notice which have been issued, the respondent authorities have filed an affidavit in opposition on 11/6/2024. In the said affidavit in opposition, it has been categorically submitted that the respondent numbers 2, 3, and 4 is only liable to pay an amount of rupees 47,415.6 and the 61, and the remaining amount which the petitioner claims is being seriously disputed. Full stop. Taking into account the above, full stop. It is further seen that the petitioner thereupon has not filed any reply even after a period of 1 year have passed by. Full stop. Considering the above, it is therefore the opinion of this court that these being the disputed questions of facts, this court cannot pass appropriate directions, thereby directing the respondent authorities to make the payment of the amount as claimed by the petitioner. Accordingly, the instant petition, therefore, however, it is also the opinion of this court that the petitioner has been diligently pursuing the present writ petition. Accordingly, the instant writ petition, therefore, stands disposed of with the following observations and directions. The respondent number 2, 3, and 4 are jointly and severely directed to pay the petitioner an amount of rupees 47,415.61 paisa within a period of 6 weeks from the date a certified copy of this order is served upon the respondent number 3.
Respondent number 4.
Respondent number 4. As regards the remaining amount which the petitioner claims, if so advised, and claims, the petitioner would be at liberty to approach the competent civil court. Is there any arbitration clause? No, no.
No, but there was some third party intervention is there. If there is a bill amount is disputed, there is a clause in purchase order, then contractor may approach the third party for measurement and.
No. Is there any arbitration?
No.
Shall approach the competent civil court. Full stop. The period during which the instant writ petition has been pending, that is, with effect from 10/9/2021 till date, be excluded while computing the period of limitation. Next. The dismissal of the prayer of the petitioner in respect of the entire amount as claimed by the petitioner by way of the present order shall not prejudice the petitioner before the competent civil court if any proceedings are initiated.
Item 9.
Please, Your Lordship.
What is this?
Lord, here the petitioner has challenged the decision of the respondent authorities, FCI, my Lord. As regard, my Lord, deductions of the amount for the reduction of the distance, my Lord. The contract was awarded to the petitioner herein, my Lord. The distance where in the NIT was 315 kilometers. Lord, we have worked out, my Lord, executed almost entire contract, my Lord. Thereafter, my Lord, they worked out a calculation in their terms saying that the distance is reduced to 295 kilometers. And they, my Lord, sought to recover the amount. And so far as pending bills, my Lord, they wanted to make payment with deducted rates, my Lords. And, my Lord, we submitted a representation that was not considered. We moved before your Lordships, my Lords. Lord, since there was a grievance redressal forum, my lord, the lordship permitted us to approach them. But subsequently, we approached the authorities, but they passed the speaking order, my lord, rejecting our claim, my lord, and upholding the decision of the FCIs. My lord, a similar issue has been decided by your lordships, my lords.
Dismissed, allowed.
Allowed, my lord.
Okay.
But I will indicate to your lordships, my lord, the FCI has filed an appeal, but that is coming up on 30th. No, there is no stay order as such. There also, my lord, the distance was reduced from 90 kilometer to 74. Yeah.
Who has filed appeal?
No, the FCI. FCI.
She has filed an appeal again.
There is no stay order as such. My lord, I
Huh?
can put it. There is no stay order, my lord, that has not been admitted. My lord, thrice they have taken time, my lord, and it's been fixed on 30th of October. I have checked, my lord, writ appeal 159 of 2020. Mhm.
So, should we wait?
Let us wait, my lord. Meanwhile, I will also go through this judgment, my lord.
You have filed an
Separate
appeal.
counsel was there. Separate counsel was there. Otherwise, there is also a decision, my lord, where the committee in other similar situated cases, where in the NIT, if the distance is given 314 kilometer, but after the committee report, it has been found to be a access more deep, kilometers, my lord. Thereafter, the Honorable High Court has held that the access amount has to be paid. So similar reasoning has to be applied in this case also, where now after the committee report has found that the actual distance is reduced to 295 kilometers. So he will not be entitled, my lord, because the actual distance covered is 295, not 314 as depicted in the NIT, my lord.
And why did you issue the NIT in that manner?
My lord, that
Huh?
reasoning cannot be applied, my lord, in two different.
What?
I would be relying on the judgment rendered in any trade, my lord, and the GB holding, my lord, wherein in that case,
Who has delivered?
it was delivered by the Honorable Justice Munstam and the Honorable Justice K.K. Kustan.
Division bench.
The division when it has been upheld.
Show me that.
And 2019 5 GLT 385.
Yeah.
How is this relevant? Any trade?
Any trade, my lord, in this case, my lord, the NIT, the distance was 295, but later on the committee report has shown that it is actually in the NIT it was shown to 43, but after the calculation, my lord, the actual distance found out to be 295. So the honorable court has held that the actual distance has to be paid. Similarly, in another case,
ये दोनों पूरे आगे वही हो जाएगा, दोनों में से एक प्रिंसिपल एक और कॉन्ट्रडिक्शन एक फिर लोगे या ऐसे होगा, मिनिमम है तो दो, तो इसमें सबसे बड़ा एक किसका जजमेंट रिफर किया हुआ है, एडमिशन नहीं हुआ 30 तारीख को नहीं। 90 से 74 तक रिलीव रीजन, ये जो एग्रीमेंट में है वो बाइंडिंग है, टेंडर देयर इज नो क्लॉज विच टाइटल की आप रिड्यूस कर सकता है। एक डिस्टिंग्विशिंग किया है, एक कौन सा किया है, ये किया है, ये तो कभी सेम किया था, किया था फिर
Here the case is different, any traders. How do you have this any
no, my
traders
lord,
applicable?
here in the any trade, the NIT, the distance was was.
No, it is your, in fact, the FCI wanted to make the payment. That's it, that's the, was the stand.
No, FCI
But
didn't want
later on, what he did, he, for future, it's kindly come to paragraph 10,
my lord, any trade or GB Chaudhary.
any traders, any trade. Paragraph 10. The competent authorities conveyed approval for payment as per the genuine and in doing insofar as the rate to be paid to the petitioner for the extra distance area was concerned, FCI also finalized the rate at so and so for the entire distance of Iman. As the petitioner from transported a quantity of so and so will recalculated the total amount payable to the as transporter so and so on the basis of the revised rate, that is Iman. As the original estimate for the distance of Iman was 1 kilometers for the quantity of Iman was Iman, the differential amount was calculated as Iman which the FCI decided to make payment. The same decision on revised rate was communicated to the petitioner form for the year. It was mentioned that here they were unilaterally reducing it.
In the any trade, my lord, the rate was
Not applicable. Next.
Like the GB Chaudhary. Paragraph 6, it has been stated, the facts has been stated. GB Chaudhary, originally it was stated at 232 kilometer, but it was found to be 284 kilometer. So relying on any trade, The honorable court has directed to pay the actual rate.
So here what has happened is the rate at which these people, in both the cases, the petitioner had quoted a rate of something.
Yes.
Taking it at 243. Actually, it is 295. So when it is 295, the petitioner wanted the same rate at 295. And on the other hand, you try to
Taking the
proportionately reduce the kilometer rate.
No, my lord, in that case, L2 was if we calculate the 295 rate, then the L2 become L1. So we stated, we have given the proposal that we will give you at the L2 rate. Because now L2 become L1 because of the increase rate. So that proposal was not accepted by the honorable court, and the honorable court stated that you pay the entire distance at the actual rate. Now in the GB Chaudhary also, it has been held that you have to pay the additional distance at the quoted rate. So now the principles that whatever the committee report has decided, the court has accepted that, okay, this is the actual rate. Now here that principle I want to apply that now here the actual rate is, actual distance is lesser than what has been stated in the NIT mine. Otherwise, my lord, two judgment will be there on.
No, that is the different judgment. Your case in
This
those
will be
any trade judgment and the other judgment of Justice Shyam is this. The particular rate at he quoted some 11 rupees 48 paisa, taking it at 243 as a kilometer. Subsequently, it became 295. So he wanted to enhance the rate. And he wanted that these 11 rupees should be paid for as 295. For 295 instead of 243, because you are paying as regards 243 kilometers. He wanted that 11 rupees 48 paisa should be paid for 295 kilometers. That is his representation in that case.
Yes.
What you did is you proportionately reduced it.
So we said that the L now because of the
That is understood, but you proportionately reduced it on the basis of 295. Kindly see what you have done. And therefore the court said you cannot do that. Kindly come to paragraph number.
Yeah, that is there. The court said that we cannot do that.
You cannot
have to
do
pay
that.
the rate of the actual distance.
What do they say? Say, paragraph 9. Acting on the representation of the petitioner, a committee was constituted by the FCI authority to verify and to find out the shortest motorable distance from so-and-so to so-and-so. And the members of the committee, after covering the distance by the vehicle themselves, submitted a report on so-and-so to the effect that the shortest motorable through the track was flying was 295.10 kilometers, which meant the extra distance of Iman, after it was confirmed that the extra distance between so-and-so was 295, the matter of payment of extra distance of Iman to the petitioner was considered at the end of the FCI. So therefore, he asked not that he should be given this 1148 for 295 kilometers, not for 242. That was the case. The competent authorities conferred approval for payment as per genuine NAER. In doing so, insofar as the rate to be paid to the petitioner for the extra distance of Iman was concerned, finalize the rate at 948. Thereby you reduced it.
Yeah.
For the entire distance of Iman, as the petitioner firm transported quantity of Iman during the so-and-so, the total amount payable to the petitioner was transporter contractor Iman on the basis of the revised rate of Iman. As the original estimate for 243 kilometers at so-and-so for the quantity of Iman was rupees Iman. The differential amount was to be paid was calculated at rupees Iman, which the FCI decided to make payment. So you wanted to make payment at 948, although it was 1143. The petitioner's case is you have to give me at 1143 only for 295 kilometers.
But in the GB Chaudhary
That
case,
is, there is no relevance out here.
but in the GB Chaudhary case, this will be applicable, my lord. There was no reduction of the rate.
No, that was followed in this judgment. Now here is
My
the
lord, in any
case.
my lord, let this matter be come up after this 38, my lord, I will.
Why? File another appeal.
My lord,
I will go through this, my lord, this judgment, my lord. It is rendered by your lordship.
File another judgment. And when was the contract over?
my lord, in 2017, my lord.
And when did they make the demand?
Before that, before the expiry
My
of
lord,
the.
during the continuation of the contract period.
They made the demand. But here it was made after 5 years.
Yes, my lord, part of, my lord, there is one more fact. Part of the amount 25 lakhs, my lords, your lordship has not entertained because that has already been deducted earlier and they had not challenged that. And they have made the demand belatedly. There the security deposit was refunded. In my case, it has not been refunded, my lord.
So therefore, here was a case that a contract had come to an end. That is what
Yes,
by
yes.
paragraph
No,
46,
yes,
48,
my lord.
the contract between the petitioner and
Has
respondent
concluded.
could validly discharge upon the issuance of the respective no demand certificate
My lord.
and the refund of the security deposit.
Yes. Unlike
The
in my case, my
imposition
lord.
so made by demand notice dated was known as void and accordingly interfered with.
My lord.
So therefore, how will this judgment apply?
My lord, the other aspect of this judgment, my lord. Your lordship has said that, my lord, they don't have any provision by which they can reduce the distance and claim that. My lord, there are two parts of it, my lord. Your lordship has decided also on that aspect that the contract remained concluded, and the other one, your lordship has decided there is no provision because they had tendered that distance, my lord. So they could not have reduced it.
Now here the term was
Both.
that the distance has to be calculated as per the what the chief engineer said.
My lord.
It's same term.
My lord. Same. So that part is, my lord, common in both judges because they have finalized.
It has been submitted by the learned counsels at the bar that the the issue involved in the instant repetition is covered by it has been submitted by the learned counsel appearing on behalf of the petitioner that the issue involved in the instant repetition is covered by the judgment of this court in the case of GB Holdings Private Limited versus the Food Corporation of India and 3 others, delivered in bracket of the WBC number 66/2024, decided on 23/1/2025. It has been further submitted that an appeal there against have been filed before the learned division bench of this court, and the appeal is fixed for consideration on 30/10/2025. Taking into account the above, both the councils submits that the matter be taken after the disposal of the said appeal. Full stop. Take writ appeal number
159 of 2025.
Taking into account the above, the instant writ petition be listed after the disposal of WA number 159
of 2020.
9/2025. Full stop. The registry shall duly list the matter immediately upon the disposal of WPC number so and so. Full stop. The interim order passed earlier shall continue in the disposal of the writ petition.
Can I make one prayer? Your lordship has said after disposal of the writ appeal, my lord, that may, my lord, if but may I pray the matter be taken sometime in next second week of
Why?
November?
There is already a
Lord,
stay.
Lord, my security deposit and everything is stuck up with them, my lord.
So it is
So if there is
depending on
no stay,
disposal.
if there is no stay order, as of now, they have, my lord, moved in May 2025. 3 dates have been taken. So far, it's not been admitted.
And is fixed on so and so for consideration. বুলি লিখিলে না? বুঝতো? Taking into account the above, list this matter on 8th of December 2025. The interim order passed earlier shall continue till the disposal of the petition.
Is not that big a record.
Non-payment.
Yes. Now, we have executed a work, the work of allotted by Jorat Municipal Board. Now, they say that they are to receive funds from the Union of India, Union government. So they have not received funds from Union of India, so they could not pay us, the project was stopped. So
Union is not a party.
they have not filed an affidavit, madam. But their Jorat Municipal Board stand is that as we have not received any funds from the Union of India, so we cannot pay. Respondent number 1 is the Union of India.
You are concerned with the fifth bill.
Fifth and sixth bill plus, my lord, this.
We have stopped construction.
We have stopped construction on 15, my lord, because they were not paying the bill.
So if you have stopped construction, then and why you are approaching this court of
No,
a
lord, they have said, my lord. The lordship will kindly come to page 47. It is their reply, my lord. Page 47 of the writ petition. Page relevant portion is page 48, my lord. Page 40 is page 48, my lord. Clause 4 and 5, my lord. The Jorat Municipal Board has been communicating with the concerned authorities for implementation of the project at the new site at so-and-so. Revised project at new so-and-so has already been submitted for approval with the request for necessary arrangement for getting subsequent installment against the project from the government. The board will the next line, my lord. The board will reschedule the timing of completion of the project.
Paragraph 7 of the affidavit filed by.
Yes. They said 2000, next para 9 also, your lordship will kindly see their affidavit. The petitioner was given the second already paid an amount of so and so against this running, but the government of India has not released the sanction amount.
It's okay, but the fact remains that why we approached this court so late?
No, we have 2017. They have said, my lord, that we are they will pay 2000. Para 4 and 5, my lord.
No, in
Para
2014 only you know about all this.
No, para 5(4), my lord, last paragraph, the board will reschedule the timing of the completion of the project on approval from the government.
As on date, we don't know whether you have completed or not.
Let them, they have completed or not, my lord.
They have categorically stated.
Yes, they have categorically stated, my lord. So there's, as regards the pending bills of, my lord, fifth bill and sixth bill.
Go to the civil.
Yes, as regards fifth bill and sixth bill, we will go to the civil court. But as regards the security deposit that is lying with them.
Security deposit, how can you get the security deposit if you have not completed the work?
Well, they themselves are saying that they will reschedule the work. Page 48.
No,
will kindly see, my lord.
Unless you say
No,
that
they
you
are
have
saying, my
completed
lord,
the
my
work.
lord.
They have categorically stated in paragraph number 7 that you have not completed the work.
No, my lord, how will I complete the work if they themselves are saying that they will reschedule the work because of non-payment of.
Whatever may be, then how can you be entitled to the security deposit?
My lord, the security deposit has been deducted from the bills, my lord, from the bills which they have made payment, running bill 1 to 4. Now their stand is that as they have not received the funds
Show me the tender that you are entitled to the security deposit when. Show me from the tender. When are you entitled to the security deposit? After completion.
After completion, but they themselves are saying that they
concerned with that.
They,
That
my lord,
this
it is
court
there.
cannot, this is not a court for that.
My lord,
If
they
there's an
themselves
amount
are saying
due
that,
out
my
there,
lord.
first of all, that is it. Secondly, these are questions of 2014. Why should they?
2017, my lord, 2017, they are saying, my lord.
You stop construction from October 2014.
No, my lord, 2015, my lord. The letter is there, my lord. Lordship will kindly see page number 35. We have informed, page 35, September 2015.
Regarding what?
That informing that because of non-payment of fund, we are not in a position to carry out with the construction, my lord.
Inform you the construction of the have been stopped by me due to non-receipt of the. When did you stop?
On 9/9/2015, 9/9/15, my lord.
You have informed it. When did you stop? They categorically say that you have stopped in the month of October 2014.
My lord, with reference to the subject, I have the honor to inform you the construction work have been stopped by me due to non-receipt of
So
This
that
is the
is-
reference to
It
discussion.
doesn't say anything that you. When did you stop?
Well, as per this letter, they have stopped on 9/9 and they have
Go
intimate.
before them, man. No.
Now, my lord, their stand is that because of non-release of fund, because it was from 10%.
You were given at a contract price of 14 crores 90 lakhs.
Yes, my lord.
Out of which 2,97,000 you have got.
We have been paid.
Now you have done some work.
Fifth and
running
sixth
bill.
bill. Yes, my lord.
Fifth running bill, then you stop your work.
Yes.
Now, therefore, you show me that how on earth can you get the security deposit if you have not completed? Show me that.
My lord, what was that?
As per the terms and conditions of the contract, when can you get the security deposit?
So let me get the my lord,
Okay.
clause 22, my lord, page 32.
Clause 22 is work not to be
No,
sublet.
on left hand side, my lord, down will contract may be rescinded and security deposit forfeited for sublet things bringing off or contract makes
This
some.
is for
This is
subletting.
the but regarding security deposit, my lord, I don't find anything, my lord.
Then there will be 100%, there will be on the final certificate being given then only. You cannot get the security deposit before that.
So that is why, my lord, what is the stand of the union? Their stand is stand because
Yeah,
they say
yeah. The amount of percentage, yeah. The time allowed for carrying out the work as entered in the tender shall be strictly observed by the contractor and shall be reckoned for the last date of so and so. And further to ensure good progress during the execution, the contractor shall be bound in all courses in which time has been given. And in the event the surety being reduced by the reason of any such reduction of sale, the contractor shall within make the good so and so. And say, in any case in which under any clause of the contract, the contractor shall have rescinded himself liable to pay compensation amounting to 50% or more of his security deposit The executive engineer on behalf of the provincial government shall have the power to adopt any of the following course: to rescind the contract as to which so and so, and in which case the security deposit of the contractor shall be forfeited. Huh? No case.
No, it is because of their, my lord, their stand.
There you also know when the contract was awarded to you, what will happen.
No, at that time, my lord, because if we had known how they have paid 4 running bills, my lord, the 4 running bills they have paid, my lord. Now thereafter they said that this fund they have not received from the Union of India, so they now in their affidavit they have made a categorical statement that as they have not received any fund from the Union of India, so they cannot pay any money, my lord, to the petitioner, my lord. Page para 9 of their affidavit in opposition, my lord. They say that but the government of India has not released the sanctioned amount after release of sum of rupees so and so out of the total sanctioned amount of so and so in question, and the petitioner has stopped. The Jorhat Municipal Board is not in a position to further execute the work and make the payment to the writ petition against the said work. Out of
Go before the civil court.
But yes, regarding that, my lord, fifth and sixth bill, they and other claims they will go to the petitioner, will go to the civil court, but at least the security deposit, my lord.
No, security deposit, nothing doing. Nothing doing security. It's a case of rescinding. Whether there is a case of rescinding or not, that has to be looked into by the trial court. Whether there is a proper or not, whether you are entitled to the entire amount or not, that you have to get it from the trial court. Not here. They've also issued notice under section 80 and now you are coming before this court. Bad case.
The liberty, my lord, to approach.
No, obviously, I'll give you the liberty. Heard Mr. A. Das, the learned counsel, appearing on behalf of the petitioner, Ms. So and so, who appears on behalf of the respondent on
3, 4, and 5. 3, 4, and 5.
3, 4, and 5.
11, Well,
Then Lordship, in terms of the said order, Lordship, they have not considered but Lordship and then approach this honorable court. And this honorable court, Lordship, order dated 23/2024, passed and Lordship in this matter. 3/2024. 20, Lordship. Passed an interim order, Lordship. But in the meantime, my London friend appeared, Lordship, filed an affidavit. Lordship. My response submission, Lordship, kindly consider the beaters to the petitioner, Lordship, and in other.
As on today, my instruction is, Malad, there are ground floor and 2 floors, first and second. In the ground floor, there are 47 shops. Those 47 shops already given in the affidavit we have said. In first floor, Malad, if the petitioner is agreeable, Malad, they will consider in the first floor. First floor, second floor.
My
there.
rescue
In the first
submission,
floor,
Lordship,
it can be.
if any vacancy inside, as per my instruction, Lordship, in the middle portion inside the ground floor, rooms are vacant, Lordship. So if any vacancy is there in the first floor, and if not, then
47 allotments have already been given in the ground floor. There are 47 shops in the ground floor. There is no, as per my instruction, there is no vacancy.
and
In the
also
first floor, Malab, they can consider.
Lordship with the rice and other
Grocery.
things, grocery shop. And because Lordship, and they also page 57, I have given an affidavit, Lordship. I have thrown an RTA, came to know, Lordship. Eight. Lordship. No, Lordship, I will not disturb anybody, Lordship. My prayer is not that. Lordship. Lordship leaves.
Let him come. Lordship. LOTs. Well, first floor and second floor are open space. There is no room in the first floor and second floor. There is no room in the first floor and second floor. Rooms are only available in the ground floor. First floor and second floor are open space. They will be allotted in the first floor. Space. It is space in the first. Well, it is their contention. We denied. No, we deny in our affidavit. We deny because in the actual shopholders list, a subcommittee was appointed by the board. In that list, they are not there. But even in any case, since the deputy commissioner order is there, they will consider in the first floor and second floor. We are not taking a lottery to that. They claim. Deputy commissioner finally said that if vacancies are there, you consider them. Well, that list was prepared, but in fact, the municipal board has appointed a subcommittee to see who are the actual shopkeepers. In the actual shopkeeper list in our affidavit we have annexed, their names are not there. That is why they were not considered earlier. We are not taking a lordship to that dispute. They will approach the authority. There is an order. There is an order here. There is an order on 20th of March 2024. Although all the 47 in ground floor already filled up on that particular day prior to that day, let the petitioner approach the authority lordship, and accordingly they will consider. Lordship has directed.
May I submit?
They will consider.
Because
Yes, my lord. Let them go.
Lordship.
My lord. They will because
Yep.
Lordship.
Lordship. Even then, Lordship, they also
allotted the person, those who are not even from the list. Page 57, I have stated in my additional in the ground floor. So let my learned friend be produced with fairness. I am submitting. Who are those 47%, Lordship? They are not the original beta holder, Lordship. And also this honorable court earlier also paid Lordship. If necessary, Lordship. I am not on Lordship with then if anything, Lordship, I may raise any file additional affidavit of a Lordship, please. Let them file, give you at least a lot, then Lordship. Much obliged. Lordship. Lordship, please.
Just for non-payment of, yes, non-payment. Yes, sir. Yes.
Sir. 15.
Right.
No, I will make, it's FMP scheme, madam. I have not met the party in central government or in Union of India and water, Brahmaputra board. Well, Jal Shakti and Brahmaputra board, I will implement them the party. In this case, and also my lord in case number 19, my lord, item number 19. I have not implemented yet, ma'am. They have filed.
My lord, we have filed affidavit, my lord, but they have not related a central government of the party.
In the last occasion, madam, the copy I have sent to the court.
Affidavit. Oh. It- My lord, that work completed in 2005, my lord.
2012. By the of the year 11, 12.
What for the?
The year 2012. Period of
Only 34,000.
My lord, please wait. Water Resource Department.
First, we'll move on to proposal. Any information
The respondents have taken basically the orders of the year 2012. And the petitioner had approached the year 2023. Taking into account the above. This whole issue. That the petition become indicating that the time to cover the target of the Constitution, on which they usually stand this. The part of the report is
The department should.
Item 16.
Please, my lord. My lord, matter is relating to non-payment protection field, my lord. My lord, information, public relation, printing and stationery department. My lord, 2015, 16 and 17, my lord, and I am communicating with the department, and my last communication letter is at case 48, my lord. That is of 2022, my lord. And from since the date of pending, my lord, I am communicating with the department, my lord.
appeal verification and the verification. The petition agrees to the bills that are not clear. However, not paid in spite of petition. 11-1
See that the treatment application has been completed by. It's like a few of the petitioner by the property takes the time. So, by the.
Hello. 20.
My lord, yes, item, my lord, 25 or so. Yes, otherwise, my lord, admitted, amount is admitted, but maybe there may be some, not sure. That will be item 14, I suppose, item 14. But may I place the instruction, lordship may keep it in the part of, as a part of the record, my lord. I've got the instruction, admissible amount is there, mentioned. Para 6. In the third page, my lord, para 6. My lord, only thing, my lord, lordship will say, my lord, they will verify and make the payment as per the terms of the contract, because completion certificate has not been issued. Probably there may be some, my lord, error, or my lord, work, maybe, my lord, not as per the satisfaction of the authority. So whatever is there, my lord, amount has been admitted, subject to any, my lord, further terms and conditions, my lord, of the NIT. Last line. Obligement.
Item 21. Twenty-two.
Oh, please, your lordship. Lordship shall come to page 274. letter dated 14/11/2019, Lordship. There was an instruction for Rajdhani Shatabdi Duronto train. In it, at para 2, Lordship, and para 1, the revised menu for Rajdhani Duronto Shatabdi train shall be as per the enclosed annexure. Their Lordship, thus the delegation given to IRCTC with a commercial circular number 10 of 2019 for deciding the menu for catering services on Rajdhani Shatabdi Duronto train shall stand withdrawn. So the revised menu and tariff was to be decided by the Indian Railway. So when this impugn communications came, Lordship, we had challenged, filed this writ petition challenging the jurisdiction of the IRCTC in issuing the impugn communication. Lordship, IRCTC. Yes, Lordship, commercial circular number, it's the communication bearing 2019 SBD, letter dated 8/4/8 at page 31. Lordship. The modalities for assessment of sales in mail express, RSD and DSB. 8/4/22 at page 31, Lord. Eight 4/22, 8/2/23. That's it. Put these two communications. 8/2 and 10/8/23. Because they have intermeddled with the earlier formula, Lordship, by setting and made a new formula as well, which could not have been done by them, because it's the power vested on the zonal railways and not on the IRCTC. They have revised the menu and tariff. Yes, Lord. Yes. Yes. Yes, Lord. We are challenging the sale assessment, Lordship. I haven't annexed it.
My lord, in fact, my lord, they are relying on 2010, my lord, the policy, my lord, but after that 2017 policy came, and there is a tripartite agreement with the railway, my lord, IRCTC and them, my lord. If lordship find at page 223, page 223. My lord, because the all powers has been given to IRCTC now. Now, after catering policy, my lord, 17, my lord, they mention it here. No, well, that has been given, full power, to them, because now IRCTC is dealing with this, and IRCTC has extended the contract because the earlier contract expired long back. Thereafter, 2018, then IRCTC extended the contract, and now, what happened? The value, has been increased. License fee is to be revised. We have revised the license fee, because if you also see, at page 34, how we have revised it, 34, Earlier, if you this circular, that calculation, meals value as per license billing. Earlier, value is this much. Now, as per the, now, it is 18 crore so and so. Now, new sales, so we have increased is 6 crore and so. That increase is 49%, 49.4%. Accordingly, license fee has been increased, because the value of the sales, we have increased the license fee. That is what they are challenging. They are saying that, that we have no power, we relying on 2010 catering policy. Now 2017 catering policy has come, and that is why tripartite agreement was entered into with them, and extension is granted by us, not by the railways now. Is all this catering business, oh, yes. 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 So interim order is there, that is why we cannot, implement it. Yes.
Lordship, will come to page 274. And the order dated, this order was passed by this honorable court back in 8/10/23. Order dated 8/10/23, Lordship. 8/10/23, the first order passed by this honorable court. 8/10/23 order. The order passed by Justice Michael Juthan Kumar on 8/10/18/10.
1810.
The demand for revised letter. So he hasn't yet produced that.
That is still there, page 34, That is what, we did not require more, Page 34 says, how we have revised the right. The earlier sale was there, present sale is there, after, because we have increased the value of the foods, Railway is a party, railway, nothing to say virtually, because they have, entire business has been given to the IRCTC, Because your lawsuit will say page 35, how we have increased the value, price, Original price existing tariff is 32.50 for breakfast. Now it has been become 45. In this way, we have increased the license fee only by 28%. Yes. Consumer. They are taking from. Yes. Divide.
If you are carrying on a contract, are you making the existing? No, Lord. Or the price. On the revised tariff, Lord. You are taking the revised tariff, then what you, then how can you take on the revised tariff? You are taking on the revised tariff, then we increase the license fee. On one hand, one side, doesn't. We don't want to go. On the other hand, you are acting on the right. No, this letter has been stayed, Lordship. Yes, it has been, Lordship.
No, well, yes.
Yes, Lord.
Otherwise, they could not have realized, revised tariff, they could not have realized, my lord. But they are realizing that. Yes. Yes, they are taking.
That part I'll have to take instruction. You are taking a revised tariff, but you want the city inside of that. How makes it? We won't do this better. We have to come up with the. Yes. The revised tariff. Obviously, the revised tariff is to be keep. And according to the license fee has been made by the. Percentage of change the ticket. We are now. So 2 weeks, Lord. Let me file the rejoinder of. By this time, let me file the affidavit in reply. After 2 weeks. So you have to pay 1,05,000. Are you running these things?
Yes.
Yes. How can it?
The respondent hires. Like the internet like on the basis of the formula to mention in the communication between how the this was the revision of the license fee is on account of the revised tariff in respect to various services. The scope and environment which we shortly the council appearing on behalf of the petitioner as whether the petitioner are claiming the revised tariff or the existing tariff. And budget. See that on account of the revised tariff. There is a corresponding fee to the license. The lower council directly. The lower council has also defined that
That's okay. 23,
Maybe Your Lordship. Regarding the non-payment of contractual bill, the GMC authority had issued work orders. If Your Lordship comes to page number 17. Reply, they have said, before, I mean, you can reply, my lord, I'll show Your Lordship one thing, madam. If Your Lordship coming with the case number. No, madam, they have admitted. Kindly see, madam, 113. AFDP, they says that paragraph number 5, madam. Paragraph 5, madam, yes. Proceed may come case number 113, madam. 113 of my petition. 113. I filed the RTI application, madam. They have answered that payment of the bills are not released due to lack of signature of the then executive engineer. My affidavit in opposition filed by them is at case number 115. Paragraph 5. Paragraph 5, madam. But admitted amount, the lordship will come to, lordship may come to page number 113, madam. Opposition, they say that they have not denied the work, madam. They say that the concerned engineer was behind the bar. Madam, case 113, madam. This is the minutes, madam, which I have taken by an RTI, madam. Petition, madam. Yes, ma'am. This one. Thereafter, my I filed a reply to this activity in opposition. If your lordship comes to page 126 of my reply, next one 9. The first paragraph, madam. Rest of for others and all. My is not, and during investigation, no sufficient evidence has been found to have been committed by the above firm in committing criminal misconduct. But my name is Ms. Pallavi Sharma, and there is no allegation against me. They say in their contract affidavit that the concern file number so and so has handed over to the Chief Minister Vigilance on so and so. The same has not been returned back. Date 26.
Earlier it was.
Hello. He is referring to the letter of the Chief Minister Vigilance Cell. Vigilance Cell has taken the file. They have come to conclusion that there is no such evidence to put him behind. Yeah, that is it. But they have to return the file and process it. The file. Because we have not go. We have not the opportunity to go to the file. What is there, my lord? Because that's the difficulty. The moment the file comes, we'll process it. And if there, first of all, the signature has to be. The person who will put the signature, he has been arrested. But one thing, in their minus manner, which I have taken by an RTI, they says that there is no signature of the engineer. So my and there is all right.
24.
Please, Lordship, this matter pertaining to non-payment of minor non-payment of murder, earnest money and minor security deposit matter. During the pendency of this petition, minor. All total 2,08,080 matter. 2,08,080 during the pendency.
My lord, I'm just getting an instruction. My lord, my instruction says that, my lord, the second page, my lord. Already we have released that SD amount and only some now 18,000 rupees, everything is paid, my lord. Only that some 18,582 is still held up and others has been paid, my lord. I don't, maybe there was no budget, my lord. That time, my lord, when there was no budget, that is the thing I knew, my lord. So I told them that you pay this also. So, it was second page. Payment due to second page. My lord, that 1 lakh also, my lord, that was sent to the bank, my lord, for payment, my lord. That's the document. My lord.
Over there, 50,000. Fifty thousand. 50,000.
In this matter, we have filed an affidavit, my lord. They haven't served us a copy, my lord. I'm appearing for the TAD, the petitioner, my lord. We have filed an affidavit in opposition in this matter. They haven't served us a copy, my lord. They haven't given us a copy as yet. They have, I think, given the PWD, my lord, most probably. But we are the main party. GAD, my lord. I am appearing for GAD. The PWD has received the copy.
I will supply the copy. Entire year we have challenged the appeal order page 41, Your Lordship. The respondent they have come for recovery of the hearing. Entire notice was issued for operating the canteen of the Samhita Bhavan. I was the successful bidder. And in pursuant to the that order, they have to supposed to execute agreement with the present petition. But during the pandemic,
I was not allowed to operate initially to the order, but subsequently from January 2022, I was allowed to operate. But no any agreement was executed there. And subsequently, without executing any agreement in terms of the order of allotment, Your Lordship, they have already terminated me from the tender order, Your Lordship, and they come for recovery of the amount without ventilating the demands raised by the petitioner before the respondent by way submitting representation to the law. Lordship, they are demanding the entire amount because of they are in the impugn order, Lordship will find, they have case 41. They have shown me as they have projected me as an unauthorized occupancy. Currently, they have quoted in section 2H, Your Lordship, in the first page, Your Lordship. It's unauthorized occupation. And in view of that, Your Lordship, they have come for recovery. Or in the meantime, they have already terminated the tender, Your Lordship. Page 39 is the order of termination. Also, there is no agreement executed with me, Your Lordship, in terms of no, you are not, because of that time, Your Lordship, that time also pandemic is going on, Your Lordship. I was from January 2022. 22, it was terminated on 6th. Lordship, now in terms of my representation, because they are not given me to allow operate the canteen during the pandemic period, I offered Lordship initially for 3 months, subsequently for the reason issued by the petitioner that I am ready to pay 34,000 for initial 3 months and subsequent period for the 50% of the amount, because there was no agreement was executed with me in terms of the order issued by the authority. There is no agreement. They have to issue an agreement with me, Your Lordship, in terms of the central Lordship. May kindly have a look, case 28, Your Lordship. Very Lordship. Secretary Administration Department Government of Assam please to approve Mr. Messrs. So and so. As a subject to compliance of the terms and conditions of the tender document and signing of the contract agreement to be initially for a period of 3 months, so that the quality of the goods can be properly evaluated and completion of the respective SLD as per NIT effective 1/4/21. But there is no any agreement was executed, and so far the termination part is concerned, as per NIT terms and conditions, they have to issue 60 days notice. That was also not complied with the law.
Lordship, as per that agreement again, my lord,
Page
page
25. There is no extension. That is why we are ready to pay for 3 months. That period. Subsequently, they have not neither issued any agreement with me. Not extended.
Lordship, as far as the, my lord, my affidavit is concerned, I have mentioned there, my lord, as per point 16 of the NIT, my lord, there was clear and serious misconduct. And my lord, based on that, my lord, he has filed a reply, my lord. I don't know what all he is given. My lord. My lord. My lord, if I may be allowed to bring my, that on, my lord, I have to get instruction on that part. Regarding that, because otherwise, my lord, it is regarding the recovery of the annual rent also, which he has not paid, my lord. The issue is that, my lord. So, my lord, if I may be allowed to bring it, my lord, after getting the reply, I may be allowed to, because my lord, then I'll be able to give the proper. My lord. My lord. My lord, and my lord, recovery. My lord, as per the point 16, the Secretary Administration shall have the right to review the working of the license from time to time, and if it at any point it is found contractor has failed to fulfill any conditions of this license or that his working is unsatisfactory, the SAD may terminate his license, my lord, but no such notice will be necessary if the license is terminated on the grounds of serious misconduct or any other act as commissioner. My lord. My lord. My lord, I'll just get my instruction on that part, my lord, because I have not received the, my lord, I need to get the full picture. My lord. I'll get my instruction. My lord. My lord, I'll get my, I'll get my instruction.
No, there is no intent.
Lordship, just one prayer, my lord, that Lordship will kindly fix it, my lord, after a week, my lord. My lord, let me go through the, my lord, I have not got the affidavit in reply, my lord. My lord, let me go through the reply, my lord, because that will be, otherwise, my lord, I won't. My lord, if I may be allowed, my lord, because my lord, otherwise I'll be handicapped. I'm handicapped today. My lord. That's my lord. My lord, I'll get that instruction, my lord. Have it, my lord, on the next week, my lord. That much, my lord, can grant me, my lord. I'll bring the instruction, my lord. If there is, my lord, I'll get it, my lord. It's come a long time.
On the aspect pertaining to whether there was an extension given to the person to the period of 3 months before which the petitioner was issued to the order. As to what basis the respondents can make a claim in the state of India where there was even more even work order. They have a community to run the active which the limit now to something that you could take instructions and again on November 2015. If no force of the matter to take any case.
27.
May please be lordship. Petitioner was applied for arms license, my lordship. They are very language. Just on number 3 have filed their affidavit, my lordship. The respondent number 5 is the contesting party. He, after receiving the verification report, he reject the petitioner prayer for the issuing of license, which is page number 41.
Well, we have filed the affidavit. As per my lord, the affidavit, yes, it has been filed by the respondent number 3, where it has been stated that, my lord, though the deputy commission, though the, my lord, officer in charge Dispur police station recommended for issuance of the license. However, the deputy commissioner police east and the deputy commissioner police intelligence, white report dated 1/6/2023, did not recommend issuance of the license upon assessment of the trade perception. So that's why it has not been issued. Madam? Madam? No, that trade perception, it is a petitioner will have to show. On that basis, my lord, they will verify. I can place the report, madam. Yes, he wants that, madam. He will have to show that for this reason he wants arms for his own safety. They will, my lord, then the intelligence, my lord, authorities, they will, my lord, verify whether there is a trade perception or not. And it has been rejected. And there are provision under the Arms Act to prefer an appeal against such rejection. They can, my lord, they have got the statutory appeal provision, my lord.
Madam, kindly see page number 46, where the SI hopefully 46. SI hopefully this could be permitted verification of arms petition.
That already we have stated in the affidavit. Down below, my lord, it is stated not recommended in the chart. And in the next page, my lord, it is there finally. Down below, not recommended. And Lord, you will see the trade perception at para 3 of the writ petition. Why he wants a license. Page 4, para 3. No, not the everywhere. No. My lord, para 3 of the writ petition, Lord, you will see. He is a contractor. He used to deal with, my lord, various labor issues. Or that on that the text, my lord, that's a different, my lord. Affidavit has been filed, my lord. These enclosures, my lord, these enclosures are not part of the affidavit. Filed one additional affidavit bringing on record this particular document. Yes, madam. Yes, respondent 5, my lord. Yes. Lordship. My lord. The same. This whole therefore direct to the commissioner of police. East and the commissioner of. It's not the party. But. The first four in which this factor of well, those are my instruction, not record, man. Yes, this is the instruction, not a record. Man. In the order lordship has recorded that I place the record. This is the instruction. Otherwise, a part of the record. Pleasure.
28.
My pleasure, Lordship. In this, the Sonan has to file a ticket. Uniform supply. Uniform. Lordship. Lordship on 24th, some other matters are also there. Yes, Lordship, today morning. One affidavit filed today morning. Yes. No, not in record, I think, Lordship. No. Copy is not maybe. No. The papers. No, Lordship.
I'm 51.
Make it clear. Lordship 51, 52, 53, Lordship. In today's list, Lordship. Yes, Lordship. Lordship, B secretary is in 51.
B53 is appearing, 52, 53 will be.
Malad, I am appearing for item number 51, Malad.
Not 54 also there. Yes.
51, 52, 53, 54. Lordship, we have allowed the registration law. Yes, Lord. If Lordship. Yes, except those matters where the last day. Yes, Lord. In all other cases we have. So what I am surviving, Lordship, these cases are not. Yes. Now, if in the meantime they participated in the tender, they participated not. That is up to them, Lordship. They are not interested.
As per the interim order, my lord, in my two cases, my lord, I've been allowed to participate manually.
Yes,
But we
registration we have allowed.
We are not allowed registration, my lord. In fact, with the court's order, my lord, in my two writ petition, I've been allowed to participate manually.
That is a different direction, Lordship. Their registration was not required in terms of the
Our
court's
grievance
order.
is that, my lord, we are not allowed.
They
to
have been
register.
allowed directly to participate without registration.
Without registration online.
In the schools,
In the
wherever
schools.
they want, Lord. That was.
We have participated. Yes, my lord.
Nothing, Lordship. Yes, sir. So, well, only one case is there, Lordship, where.
Infusion.
No, that is what I am submitting, Lordship. In one case, Lordship, guideline is under silence. Except that case, Lordship. In all other cases, Lordship, I don't think anything survived. It covers all cases, Lordship, except that guideline silence matter. One Khan matter, they are also not here today, Lordship. This affidavit will cover other matter. Lordship.
Mine. And there are two other matters, my lord.
Lordship directed us to grant registration, so we have granted. Lordship on the same day, Lordship passed the order. No, we allowed them registration. Participating, not participating, it's up to them. They cannot participate. Yeah. Lost. I'm not here. Yes.
Yes, my lord.
In some case, in his cases, Lordship, yes. Lordship, in the first two cases, Lordship, judgment passed by minor justice Ete, Lordship.
In my lord 4987, there is supplementary item 53.
52 and 53.
Lakshmi.
Lakshmi.
53 and 54, my lord. 53 and 54 are supplementary.
That Mala.
Paragraph 9 of the order, my lord, is subject to authority. Made accordingly in the interim and subject to the further order, the petitioner shall be allowed to participate in the tender quotation process manually without requiring them to be registered in the Shiksha Setu portal in those schools where the tender and quotation process has not been completed. It is made clear that allowing the petitioners to participate in the tender quotation process shall be supported. Yes.
Lots.
Lots. In one case we have filed, but in that other. Yes. In some cases. In other cases, there are challenges. We are not issued any notice. So you cannot blacklisted us without giving us any notice.
It's very, we can, it's very good. And therefore they are being allowed.
Yes. Yes.
Now, whether they can be practiced or wrong in this matter is the question.
Can you not 38 mile is not involved, 38 mile. Little difficult. October mile.
So you search for appeal of that activity file.
All the petitioners, yes.
So they want to get file.
Mile, yes.
So there is.
55 is not there, I think. 55 is.
The Rahul Enterprise.
Yes, Rahul Enterprise 54, I think. That is elementary education finance department. It's a different matter, I think. In item number 51.
Contents of the data in opposition being made in respect to other taking into account this whole direct various usual. But we copies of the activity in the other
There are two other repetition on the numbers. And there are two repetitions.
Supplementary item 48. Supplementary item 48.
Petitioner name was not included in this NRD, my lord.
Yes. Lordship, some telephonic. Lordship, some telephonic instruction has been received, Lordship. If required, we shall file our affidavit, Lordship. Yes, Lordship.
Okay. 49.
The matter regarding the settlement of market value.
Lordship has called for the records, Lordship. We have not received the same yet. Some time to be required.
No, my lord. Even the private respondent also, my lord, has not filed a petition. I have received the color note, but in case of the petition, my name appears in number 3, Noyanmoni Rava. Noyanmoni Rava, but they have, in the petition, they have taken my name, Noyanmoni Rava Bora. So later I will have difficulty because I cannot authorize my citizen. Yes, because my identity card, I don't have Bora in my time. No, in the petition, my name appears as Bora. Your name is Noyanmoni Rava. That is the difficulty I am saying. You try to be respect. Mr. D.A. Kaya, the legal counsel, appearing on behalf of the petitioner. Appearing that there was a mistake in mentioning the name of the respondent number 3. In as much as the name have been. No, one point Rava. One point Rava. And not. He therefore submitted that he may be permitted to make disciplinary verdict to the state. Taking into account of this. On behalf of the respondent number 3 and it and so that it is made that they would be loyal to the taking before thereby it's a very effective behalf of the that he may be permitted to file a reply to the respondents, state respondents, that they would like to find their reply. This is the matter of everything that reply to the file behalf and the opposition be filed behalf of the respondents or the court and One and two.
shall also include
Item 50.
His husband name is Bora, so I told that. Yes, ma'am.
I have filed the affidavit, it's not on record, but I. Oh, yeah, it has been filed. I have served the copy. Yes, Lordship will see para, my lord, 7. Paragraph 7, page 48. My lord, the security money can be, my lord, released only after, my lord, lapse of the default liability period. But here it has been extended till March 2027. So she will have to wait. 27. Para 7, page 48. Reply to
Lordship, I think we'll have to file because, Lordship, if your Lordship peruses page 38, your Lordship, the DLP completion certificate was given to us. It was issued to me, your Lordship. Page 38, your Lordship. Lordship, this is the defect liability period completion certificate, your Lordship. By the Lordship Executive Engineer, your Lordship. However, the affidavit has been filed by the Chief Engineer, your Lordship. And Lordship, it has been issued. And your Lordship, Lordship. It's point number 3 years.
Obliged.
Obliged, your Lordship.
For orders, item 29.
Question. May I please, Lordship? Lordship, contempt petition, Lordship, already complied, Lordship.
Lordship, new sets of advocates will come and they will do properly, Lordship. No, Lordship, no, Lordship, we requested him to take back the file authority. They have not come. No, Lordship, we requested authority to take back, Lordship. Complied, Lordship.
Complied, Lordship. Yes, Lordship, complied.
It has been submitted on behalf of the lawyer.
Thirty.
The Lordship newly pleaded respondent
we are appearing, but Lordship, they have not provided the representation before the authority. Lordship, we have page 13 of the contempt petition, kindly peruse. The petitioners, last portion, Lordship, the petitioner shall submit the certified copy of this order to the additional chief engineer, public works department, Bodoland Territorial Council, Kokrasar, for his doing the needful, Lordship. I am appearing for 1 and 2. 2 and 3. 2 and 3. 2 and 3. Yes. Yes. And Akashdeep. Padmananda Sotpuri. Deep.
31 and 32.
My lord, this case, N. Upadhyay is appearing in this case, my lord. Mr. N. Upadhyay is appearing in this case, he is out of station, my lord. So the matter will be for next week, my lord.
Lordship, I have been allocated to works by the BTC authorities. I have completed the work in all respect. Completion certificate has been issued. Thereafter, they want to release the payment to respond number 6 and 7. I filed a petition and this court has directed to not to release any amount to the 6 and 7. But they have released them after order of the Honorable Court. And thereafter, Lordship has directed by order dated 11/11/2024. I have filed a contempt case why it has been released. And thereafter, Lordship, this court has directed on 11/11/2024. Additional evidence specifying as to whether respondent 6.
Which will not valid.
Any read petition.
Yep.
Any read petition, they have to file a note.
Already a petition filed, for instance.
In the contempt case, not in the read petition.
So next week maybe this matter. 1 week may be given, matter. Yes, Your Honor.
What's the interim order passed and continue? File. File.
Thirty-three.
Close the contempt petition. I'm appealing for response number 1. The affidavit is in file. And it has been stated that the amount is due of 3 3. There is the affidavit from the respondent number 1, that amount is due. And respondent number 3 has been impleted later on, my lord.
The new incumbent also. They are the new incumbent. Principal secretary is now Akasdin. And
Why did you find them particularly respect to respondent?
respondent number 3 has been newly transferred as principal secretary. Four is not the necessary party also. Only principal secretary. 3 is the necessary party.
Why did taking the party and the board issues of the give up on the board?
No, sir.
The order the time the by on and by 17.
34.
Here they don't want, so therefore you need everybody. Let's wait for
Treatment. Some time to file the affidavit, my lord, because it is newly implemented.
But
35.
In this matter, your lordship, respond number 1, your lordship, sole respondent have filed affidavit and partially admitting my claim. Your lordship. This is regarding non-payment of fees, your lordship. Petitioner already paid half payment, your lordship. And during pendency of this contempt petition, another 9 lakhs has been paid. Paragraph 9 of the affidavit of. Yes, your
Well, admitted part already paid, my lord.
Total claim was 1 crore 9 lakh, your lordship.
For the rest, my lord, they have to go to civil.
In petition, your lordship. Mr. Number 4 directed the commissioner to pass an order. Out of that, the remaining part, your lordship, 9 lakh has been paid, your lordship. But for the rest of the payment, your lordship says they are disputing, your lordship, I may be allowed to approach the appropriate civil court. Out of that 42 lakhs, your lordship, 9 lakhs has been paid. And but petitioner also claiming the remaining part also, your lordship. Now says they are disputing, your lordship, the rest of the part, your lordship. Lordship may kindly may close this project, it will be me the liberty to approach this, approach the civil court. Lordship may give me liberty to approach the civil court. How? Since they are disputing, your lordship. Admitted part has already been paid, your lordship. Total claim was 1 crore 9 lakh. Out of that 1 crore 9 lakh, your department saying that I am only entitled to get 60 days, 60 days. That has been treated. And for the remaining part, I have approached this honorable court, and this product has been passed. The order which has not been complied. Order dated 38 2022.
Where does it say that you are entitled to the amount? The entire
मेरा और मैं कहीं
Yes, after verification, my lord, 9 lakhs was admitted, my lord, and that was paid. Therefore, he now, well, as per petitioner now, they already paid.
out of that remaining part, you know.
My lord,
Six. Yeah. That that remaining 2 lakhs has already been received by the.
also be paid.
yes,
So you need to
yes.
But particular says there is a remark that bill and there is an entry of the bill of total 1 crore. Yes, that liberty I am taking you.
Immediately encourage adjudication of the case from the petitioner. Either the appropriate direction being issued or making special adjudication of the case. This one the hearing of the opinion that the direction so passed by the learned court bench in the order dated 35/58/2022 passing deputation number 5167 of 2022. 5/8 one of the 2024. Report of by
Hello. 36.
Lordship, come up with a peculiar case, my lord. Lordship, government is
Today only
issued
we have filed our affidavit. Lord.
nothing new, whatever I have submitted, Lordship, my pleadings, that has come out in affidavit. No work order and no NIT, Your Lordship, but government officials issued emails, my lord, in order to supply units of materials, and there was paucity of time, Your Lordship, out of goodwill. I have supplied the materials and they have duly received it, my lord. No, they say, Lordship,
Today
today they have trickily filed the affidavit. Lordship, only one page is relevant, one paragraph. They say, they don't say they have to receive the materials, my lord. My Lordship, the deponent's office carefully verified the claim of the petitioner on the basis of the materials on record. It is found that neither NIT was invited by the office of the SSC for procurement or supply of materials of Gunotsav Guidelines 2002, General so and so, nor was there any work order. That was my case, my lord. But they have issued emails. No NIT, no work order. And I have filed several representations to issue backdated work order. Because, Lordship, the government conducted Gunotsav, my lord, and there was paucity of time. In the late week of Lordship, last week of April 2022, they have. No, my lord. Lordship, but they have duly, I'll rely on the provisions of Indian Contract Act, whether it's a void contract. Lordship, but they have utilized the materials. There are communications from. No. My lord. Verbally and via email. Email was issued. My lord. Yes, as well as I'll be relying section 10. That's like I was in dire key whether I should submit before the court. But there are communication, my lord, from the officers concerned, my lord. I'll try to satisfy your lordship on the next day. I'll rely on the provisions of the Indian Contract Act, my lord, because they have utilized. My lord, I understand, my lord, but the lordship, can I take your lordship's leave to fix a date so that, my lord? Not dismissal. If required, I will withdraw it, my lord. I'll take leave of this honorable to court to approach the appropriate forum. Lordship, just a day be given. Next week, my lord. Any day. Maybe, my lord. In a hearing day, I think Wednesday. I understand your lordship. They don't deny they have not received the amount. The affidavit they have not denied. That they have not received the material circulated throughout Assam, my lord. They don't deny. Strictly they have filed an affidavit stating that there is no work order, there is no NIT. That is my case, my lord. But under CBC guideline, they have ought to be, my lord. So, lord. I pray for a date in the coming week.
I was just my lord inadvertently not collected. My line, I'm sorry for that. My lord, I'm going to within 2 days. Tomorrow I am going to take that.
steps was taken, but were not collected as per office order, office note dated 2/12/2024, my lord. Nobody turned out up to collect the same in spite of our endeavor. Already service steps was taken, but are not collected, so thereby we are doing that within 2 days, my lord. My lord, by order dated 2/12/2024, my lord. We have taken steps, but we have not collected the environment. Tomorrow, my lord, I am waiting. Oh, my lord, I'm sorry for that, my lord. Ma'am. As well as Dosti also, I know that.
38.
Sorry for that, ma'am. Sorry for that.
May I please raise it? Respond number 4 and 6 not appeared, madam. To phrase that, madam. Yes, madam. Co-party. Respond number.
For respondent number 1. Number 1.
5 is the main party, madam. They may respond number 5, madam.
I'm appearing on behalf of Mr. G. Portaloy. Mr. G. Portaloy. G. Portaloy.
G borderline. Five, respond number 5 is the main. Deep. Sir.
My lord, actually, this is a private party, my lord. Actually, repetition is not maintainable because it is a cooperative society. It is not under the government, my lord. It doesn't come. It doesn't come under Article 12, my lord. It is a cooperative society and private institution, my lord. Organization.
Well, after filing of this case, they have admitted, my lord, and paid 4 installment after filing of this case.
It is a different issue, my lord.
My lord.
It doesn't lie, my lord.
My lord, they have status. My lord, kindly see my.
No.
Well, they have financially supported by the government, my lord, cooperative. My lord. My lord, my lord. My lord.
Yes,
The report I gave on behalf of the private companies that you like. Challenge the maintaining without the response of 5 and 6 take 5 that
yes.
taking into account the month.
Yes, my lord. I will find my.
39.
May I please your lordship? Lordship, respondent number 15 and 16. Wherever. Lordship.
Lordship, restaurant number 15 and 16, they keep on changing their address. Your Lordship, multiple, Lordship, paper publication. Lordship, I may be allowed for paper publication, Lordship. Upon restaurant number 15 and 16, your Lordship. Lordship, I'll take a fresh step. Upon restaurant number 12, your Lordship. 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 Lordship.
He is not here. No, one notice was issued by the GMD Lordship regarding that 7th floor Lordship. And all these respondents Lordship, upon whom service is not yet complete Lordship, they are residents of that 7th floor. Here, they are the flat owners. Petition. Yeah.
Lordship.
You are the flat owner.
Lordship.
And these people
Lordship, take it. Lordship. Lordship.
what are meaning that the corporation? You are a flat owner, you stay in the ground floor. All one stays in the state.
Yes.
And the 7th floor, you cannot serve them.
They keep on changing.
You have not provided the equipment. You see from the registry, no, they take 49,000. More than the 12, 15, even 17. They should get out and those steps have been taken. This matter will be a conviction of service of the respondent of the term. 15, 16, and 17.
Lordship.
40,
Otherwise, it's an unauthorized construction. That is your Lordship.
They won't take it.
And they are the sufferers, Lordship. That is also the petitioners. Because one extra floor was constructed above them, Lordship. And initially, permission was granted in respect of.
There's a tendency of the Republic on the appropriate action.
Lordship. Already we have rejected the occupancy certificate. No, no, in Lordship, at present, Lordship, 3 buildings are located on that plot. Your Lordship earlier heard this matter. One personal appearance was also there. Your Lordship passed direction, thereafter the 3rd block was cleared. And yes, an undertaking was taken not to use for commercial purpose. Yeah, Kahili Para. They are the residents of Block A and Block B. Yes.
They have changed the name of the building.
This is the matter.
item 40,
Item number 41, madam. 41, madam. It's 40, madam. Madam, first take up item number 41, madam. Wait, madam, we have complied, madam. 40, madam, by next day, madam, next we are going to comply, madam. By next week, madam.
By next week. By 15 days.
Yes, madam.
The order between the
41,
It is complied.
No, my lord, I have not yet received, my lord. Not yet received, my lord. This Samson order, my lord. Amount, my lord, I have not received.
Yes. 42.
15th of October, madam. Yes, madam.
My lord, number one.
Okay. 42.
May I please, your lordship? Lordship may kindly bear his office not dated 40th January. Lordship, service not complete.
Respondent one. It is, my lord, it's a respond number 2 and 3, we will have to do the needful, man. Finance can, my lord, only move when the proposal is submitted. When the financial, my lord, need.
Yes. Yes, lordship.
Compliance was directly taken from
From the date of order, lordship.
No, completely from the date of information.
Lordship may come to page 18, lordship. The DC Baksa. Not lordship.
Yes, sir. So this upon the complete is the matter. Hearing on the matter. By
43.
May please, your lordship.
Still lying with the, my lord, PWDR budget division, my lord. That proposal is, my lord, lying, my lord. So I can have the, my lord, updated instruction, my lord. In fact, today also I tried. They said it is still lying. But can it be, my lord, some after 2 weeks, my lord, at least I can have the
Almost a
updated.
year, your lordship, still they are processing your lordship. Almost a year. But still they are processing it. On the last occasion, that is on 8/9, they have.
On 5/6, my lord, again the proposal has been submitted. So let me have the instruction. Lords.
That's it.
44.
My lord, there's another IA similar to this, my lord, but it's not listed today, so I pray that it may be listed together, man. Yes, my lord. My lord, we could not approach on time before the additional district judge there. Could not approach on time, my lord. My lord, first of all, 30 days, my lord. 30 days, my lord. Yes, my lord. Yes, my lord. My lord, no, 30 days, my lord. 30 days. Why do you not 30 days? Well, we went there, but they say that since it is the direction from the High Court, so they cannot accept it. Since it already elapsed the period. Attempt 45, attempt 45, another IE was not listed today, ma'am.
What is your ground?
My lord, first the department was communicated with the order, with the judgment, only after 1 month of, like 1 month of the passing of the order.
What's order?
Yes, your honor. Yes, your lordship. And after that, my lord, what happened is that.
You say this, you did not.
No, my lord, the department were communicated by the council representative.
What?
The department were communicated by the council representative within 1 month.
Huh?
The department were communicated by the council representative only after a month.
After 1 month.
1 month. So after that,
You may not be ready.
not aware. After that, my lord. My lord, the communication of my lord will come the page 214. My lord, paragraph number page 7, paragraph number 6, my lord. The letter has been annexed, my lord. Madam. Item number 44, 45, madam. And IA 2228 of 2020. It is before this court only, madam. Madam, it can be listed together because that IA also is before this court only, madam. That another IA is before.
I'm not concerned that I definitely not still before this court. How can I pass forward?
In this case, my lord, so I'm appearing on behalf of the OP number 1, my lord. Okay, in this present case, my lord. No, this is not student the transmission committee, any teaching, my lord. Arbitral, my lord. Paper, my lord, my lord. But decision.
We are also happy for this question, the RDS here. We are also happy for this, because RDS here, filed by NHS here. We the opposite party go and the ID.
We are the freshly.
No, man, we don't have pen.
Yes.
45.
10.
Supplementary item 55. 46.
Please, Lordship. Hearing this case, Lordship, I am praying for correction of some clerical mistake in the judgment and order passed by your Lordship. Mistake is only in respect of name and address of the claimant respondents, Lordship. So, will you kindly see page 9 and actually 9. Respondent number 3, Nazrul Ali. He is the son of the deceased, but here by mistake the written as wife of.
How will I correct this?
And moreover, Lordship, address of the claimant respondent has Lordship. Lordship.
At the time of filing the amendment.
Lordship, my can observation made. I approach the registry. That
Because the filing of the. Well, not for the FLM, na? We are for the feeling for the 154.
Lordship.
What is your name?
Respondent 1, 2, 3, and 4. Lordship.
See, I can.
Lordship. Lordship. Lordship, I have some notice.
Hello, can you hear me?
Lordship.
Yeah.
I have some notice on Miss Asra.
Oh, it was not running. Okay. No, you give a copy to Miss Esroy. The reason why I'm saying is then I can ask her to change the memo parties. And then on the basis of changing the memo parties, this can happen. Because this is not my mistake, na?
Lordship, I already sub copy, notice also sub.
Okay, you don't need to issue notice, Mr. Lekhok. Okay. Who is Abul Hussain?
Abul Hussain is the father of the deceased.
Why you are making him a party?
I have not made.
He's not an appellant. Why you are making him an unnecessary party, Mr. Counsel?
By the order.
I am not going to pass so much of orders. First of all, you should have made only the necessary. Who has filed the appeal?
Have you filed by the?
Then why you are not making him only the opposite party? Unnecessary, how means I have to issue notice to the opposite party, meaning thereby you are going to get at the end of the day, you are disadvantaged. can't help it. If the God or anybody cannot put anything on your thing to that effect, that how will you? You need to do things by which it can be helpful for your client, not to further aggravate. The moment you are putting him in response number 2, opposite party number 2, I have to issue notice. I can't correct it. Chalo. Issue notice upon the response number 1 and 2, steps be taken by way of speed post, returnable by 6 weeks. Chalo.
If there's, I will make correction.
Oh, steps by 6 weeks. You can't make corrections. Issue notice returnable by 6 weeks, steps upon the opposite party number 1 and 2 by way of register opposite by speed post with AD.
The opposite party.
Number 1 and 2.
Like,
Yes, no steps by Dusty.
Dusty steps has been taken, but due to some problem, logistic or we could not file it.
Huh?
The lordship, Dusty steps have been taken, but due to some.
Oh, this is nothing remains. Does anything remains out here?
Relief has been granted, your lordship.
Nothing remains. Withdraw. Withdraw the petition. What a business you have. The vehicles have been released on the date on which the order was passed.
Yes, sir.
Then withdraw unnecessary. Don't burden this court. Your vehicles have been released or not? Do you want to fight?
No.
Then, Mr. Counsel appearing on behalf of so and so submits that taking into account that the vehicles of the petitioner have been released, the petitioner would not like to further proceed with the instant writ petition. Mr. So and so appears for the respondent. Taking into account the above, the writ petition stands closed on withdrawal. Chalo. Hmm.
Service completed.
Service upon the response number 4 and 5 being complete, list the matter on 10th of November for in the admission side.
If they say.
You have not taken steps by way of the speed post.
We have taken Dusty.
By register. Registered is no longer the official mode after 1/10/2025. So nowadays you don't have registered post. You have not taken steps by speed post. You have not even collected the Dusty. So it seems you are not interested. Should we dismiss it? What should you do? Huh? When I've granted you a stay, then also you have done this. You have not taken steps by the stay. So I'm vacating the stay. Directing you to take steps by speed post, you have not taken. Dusty, you have not done. So we vacate it. To be issued by speed post and by Dusty, but since steps have been taken for issuance by registered post, the same could not be issued. Registered post is no longer there. Dusty notice through prepared, turned up and collect the note. Then we dismissed. I'm not going to extend the interim till the next date. Yes, what is your stand?
Lordship, I'll be seeking some time, Lordship. Praying for some time, Lordship.
What?
I'm praying for some time, Lordship.
আবার সবাই বেয়া হয়েছে নাকি হ্যাঁ শুনা পাওয়া যে উকিল গুলো
I'm praying for some time, Lordship. If your Lordship allows me.
list this matter again on 10th of November 2025.
Can it be on 17th? Another matter.
I can have it in the month of January also. But I'm not going to extend the interim. You are okay with it? Then it is 10th. List the matter on 10th of November 2025. Mr. So-and-so appearing on behalf of the BTC, submits that he has not received the instructions. Mr. So-and-so shall ensure that the instructions are placed before this court on the next date. Next date by filing an affidavit. The interim order passed earlier shall continue till the next date. The petitioner is given a direction to take steps upon the respondent number 6 by way of Dusty, routed to the registry of this court, and file an affidavit of service on or before the next date. Next, it is further observed that if steps are not being taken by the petitioner as directed, this court shall not be inclined to extend the interim order in the next date.
57 and connected item 1 of production list.
Please, Your Lordship. Your Lordship, the applicant has moved this interlocutory application, Your Lordship, for impeachment as a party respondent number.
One number.
11.
Production list.
The-
57, this is item number.
Yes, Your Lordship.
What do you have? You have filed IA.
Yes, Your Lordship.
Who has filed the writ petition?
My lord, we have filed a writ petition, my lord.
For what?
My lord, we are assailing a work order, my lords, given by the IOCL to a private respondent. My lord,
Oh, I passed.
yes, yes. And today it was fixed for considering of interim order. My lord, we have taken steps also. Dusty service has been affected. We have filed affidavit of service also. But regarding he, my lord, he seems to be a total stranger. Because our work order is concerned about Assam and Meghalaya. And these two people which are before your lordship, they have secured work orders and they have categorically admitted that they are.
You are paying for whom?
They want to be implemented now. They want to be implemented now.
Who are they?
Yes, Your Lordship, we have secured our bids, Your Lordship, under the Stand Up India scheme, which has been contested by the petitioners, that the whole of the scheme has been, Your Lordship, discontinued. Your Lordship, the tender which we have participated, Your Lordship, the applicants, is in with respect with Manipur, Your Lordship. However, all those tender conditions, all those bids were secured, and the in-principle letters were secured under the SUI scheme, Your Lordship, which the petitioner's contention is that, Your Lordship, it has been discontinued. Yes, Your Lordship. So, and in their petition also, Your Lordship, they have also.
Oh, you are Sanjit Sarkar.
No, Your Lordship.
I am
they have
Sanjit
submitted-
Sarkar.
Who are you?
Yes, Your Lordship. I in IA civil number 3374, Your Lordship.
You are Monorama Kolita.
Yes, Your Lordship.
You are. And why one is Polasi Enterprise?
Yes, Your Lordship. Both of-
They both want to be implemented.
Yes, Your Lordship.
Why?
Yes, Your Lordship. Your Lordship, the particular contentions that have been raised by the petitioners, Your Lordship, is that, Your Lordship, the whole SUI scheme has been discontinued. Your Lordship, whereas on the other hand, we submit that there are two categories under which.
What about respondent number 8?
Respondent number 8. Your
My lord, Dusty was served to him, but he refused to accept notice, my lords.
Okay. And why are you interested? Because he's only against respondent number 8.
Yes, Your Lordship, there are, but the whole contentions of the petitioners are that or any other similarly situated SUIS bidders, Your Lordship, those, Your Lordship, bidders have to be cancelled, Your Lordship, the letter of acceptance that have been given by the IOC. Your Lordship.
Where is the prayer for that?
Yes, Your Lordship, may very well peruse their petition, Your Lordship.
Written and directing yet for giving a man to respond number as well as all consequences of. Okay. See.
Yes, sir.
My lords will be filing an objection.
No, you don't delay. Unnecessary, don't delay.
Well, I don't know because my lord.
What is there
no,
to? No, then give up.
My lord, let me explain, my lords.
Prayer
This matter, my lord, this matter was handled by Pathak, KP Pathak. Since he's attending his father today, I had to attend. After today, only afternoon I got the file, so I don't have the connection with the client. Only Pathak told me that will take time for objection. That is I'm stating. That is my instruction. I'm placing. It's up to your lordship accepts or not. I'm just placing.
No. But Mr. Gogoi, kindly appreciate. See your prayer.
My lord. Yes.
Yes.
By this prayer, if I allow this, they are affected because they got the benefit.
My lords, I understand, my lord. I'm
So
just
therefore-
placing my.
No, no, therefore, let them be made parties.
Yes, yes.
After making them parties, the question is let them file a reply.
Yes, sir. My lords.
And more particularly when the Dhiraj person,
Yes.
who is the respondent
Valmiki,
8,
yes, yes.
not appear.
Yes.
Let them appear and then come up with their stand. We
Yes.
are at the end of the day, I'm not deciding the repetition or dismissing the
Yes.
prayer.
My lords.
I'm only allowing him so that he may contest also. Let him contest on
Well,
basis of this because
lords.
in view of prayer C,
Yes.
prayer C says
Yes, I.
letter of exception issued by year in favor of the respondent by as well as similar letter of exception issued to other SUIJ category bidders. So they are. So, and what about your reply?
If you're a few days back, madam, I think handed over the plea. I'm just taking 2 weeks time to file my affidavit.
You appeared on 25/9.
The other senior counsel appeared, the plea has been given to me just a few days back.
Does the learned senior counsel appear only for himself? He has to appear with somebody.
It's Ohio.
We are not concerned. Once he accepts notice, we are not concerned who is that lawyer. We are in the fact. Okay. Chalo. Mr. N. N. Burwa. এইটো পিছত লিখিব প্ৰথমতে আয়ে কিখন লিখিম এখনত দি দিছো বাকি ইখনতো একে হ'ব ইখনত This is an application filed by the applicant seeking impleadment to the instant writ petition, to the accompanying writ petition, on the ground that if the relief number C is allowed in the writ petition, the applicant would be affected.
Yes.
First, this court have duly perused relief number C in the writ petition, and the applicant belongs to the SUIS category bidder. Consequently, this court therefore is of the opinion that the applicant herein is a necessary party to the instant proceedings and accordingly impledes the applicant as the respondent number
Page number 132. 9.
10.
10.
ফাৰ্ষ্টখনত 10
Nine.
কৰি দিব হা
10.
I8334 খন 10 কৰিব আৰু 75 খন 11 হা 11 to the instant accompanying writ petition. Full stop. Iconit 11. Accordingly, the IA stands disposed. তাৰ তলত লিখিব The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties in view of the order so passed within 7 days. And on the basis of the instant order, the registry shall make necessary correction in the cost title as well as also update the same in the CIS. এই দুটাত এই লিখি দিব হা দুটাতে এই দুখন I stands disposed. Main petition comes. Mr. N. Borua appears on behalf of the respondent numbers 1 to 4
Yes.
and submits that he would take appropriate, that he has been given instructions and would be filing the affidavit within 2 weeks. You appear for 6 and 7. Mr. A. Ganguly appears on behalf of the respondent number 6 and 7. Pusto. This court further takes note of the affidavit of service so filed, and from a perusal of the affidavit of service upon the respondent numbers
6. Yeah.
8, it is seen that the said respondent number 8 have refused to accept, considering the statements so made. This court deems that the service upon the respondent number 8 is duly complete. To stop. The newly impleaded respondent, Mr. So-and-so, appearing on behalf of the newly impleaded respondent numbers 10 and 11, submits that he had duly has the copies of the writ petition and would file the affidavit in opposition within 2 weeks. List the matter on 24th of November 2025 affidavit in opposition be filed by the respondents by 19th of November 2025. Full stop. This court shall consider passing of interim orders on the next date. I disposed. Anything more? You appear for whom?
He is the messenger, my lords.
Oh. Anybody, any more matters? No. Yes.